Morning, everybody. 9:30 and the inquiry is resumed. My name is Guy Davis. I'm the inspector appointed by the Secretary of State to hear this appeal. Appeal is brought by LSL Partners and Cirrus Land against Malden District Council, and it is for the erection of up to 275 residential units, including affordable housing, land for a children's nursery, land for an extension to Malden Cemetery, drainage works, landscaping, vehicular access, pedestrian and cycle accesses, and associated infrastructure works on a site on land west of the cemetery, London Road, Malden. We heard evidence last week on a number of matters. We begin this week continuing to look at evidence produced by three parties, the council, the appellant, and also a Rule 6 party led by Mrs. Dodson. Before I go any further, can I just do my normal housekeeping matters? If you've got mobile phones, can you please turn them to silent? For those of us with laptops, can you please also turn notifications to silent as well? There is no fire alarm test, so if the alarm does go off, please leave by the green exits and gather at the front of the building. Few things. I sent the main parties some comments on the conditions. Did you receive those?
Yes, we did, and we're having a look at those today.
Okay, that's good. Thank you for that. There are a few relatively minor wording issues. Most of them are to do with whether or not the conditions are necessary. So do they meet the test of necessity? In particular, because it's an outline scheme, and that I think is what you'll find. While looking at those, I noticed that the land use parameter plan is a revision D, and I don't think I've got a revision B. So could somebody let me have a revision D? I don't know that there's very much change between the two, but
I think this is it, sir.
please. Would you care just to explain to me what the differences are? I think it's just that the site of the nursery has been omitted. Is that right?
Yeah, we included it as an indicative location, and we amended the red line boundary, which is why the parameters were updated during the course of the application.
Right. What was the cause for the change to the red line?
It was to accommodate the change to where the crossing was on London Road, as a result of the discussions with Essex. So it was all fully consulted on.
Okay.
As part of that.
Okay, that's great. Thank you very much. I'd better make a note of that then. So where are we on the list? That will be 10. I say that I couldn't see it. I couldn't see it in the list of. Excuse me. I couldn't see it in the list on the core document library. But did I just miss it?
It should be B12, but I think there was problems with it loading with the size of the plan. I think the data layers on it. So it is there. It's all been submitted. It's in the core doc.
If it's there, then I don't need to record it as a document that I've received during the inquiry. Then that's fine. Thank you for that. Sorry, what did you just give me the CD number? Would you?
B12.
B12. Another thing that I just want to flag up now ahead of our discussions on conditions and the legal undertaking. Can I just draw your attention to a rep from the NHS? It was a rep made to the appeal, so it's a relatively recent one. In it, they are asking for a higher figure than the one that appears in the Section 106 agreement. I don't know, were you aware of that? No. Could you?
Short, no.
Okay. Could you take a look at it, and perhaps we could discuss that tomorrow when we tackle that issue.
Where?
So these are the representations that were received to the appeal.
We've not received any representation to the
None at all.
And we've chased a number of times, so that's okay.
Let me chase him then at lunch, because I think you need to see those. Right. Okay, let me check that. This is a nicety, really. Mrs. Dodsley, I'm aware that you're a councillor, a district councillor. I think you're also a town councillor as well. Now, it's at the moment I've just been calling you Miss or Mrs. Dodsley. When I record people, what happens when I write my report, I record those people who've taken part in the inquiry. Would you prefer to be called councillor, or are you happy to be called Mrs. Dodsley?
I'm happy to be called Mrs. Dodsley, sir. Thank you.
There is some logic to that, I think, because unlike, say, Councillor Fittock, he's going to appearing for the council, you're obviously appearing for a different group altogether. Excellent. We'll do that. I'll do the same for Mr. Jennings. I think he's a town councillor, is he, or is he a district councillor as well?
He's a district councillor, sir. Just district
councillor. Okay. And then lastly, I've received an additional document which is relating to the discussions we're going to have this morning on 5-year housing land supply. I think that came from the council side. Has the appellant seen a copy of that? I think it'll help our discussion, so I'm going to accept it. Yeah. Okay. Any other housekeeping matters? Oh, sorry, you've got a hand up behind you there, Mr. Grant.
So just a reminder for everyone to just speak clearly into the mic.
Thank you. Good reminder. We shall do that. Thank you for that. Yes, sorry, Mr. Grant, anything? Okay, that's good. Anything from the appellant side? Covered everything? All right, okay. Anything from you, actually, Mr. Dodsley? No? Good. Right, I think we've covered all housekeeping matters then. Let us move on to the business of today. So we are planning to have a roundtable session now, which will look into the issue of housing land supply, in particular 5-year housing land supply. And we have Mr. Pycroft and Councillor Fittock for that. And then after that, our intention is to hear general planning evidence on behalf of the council from Mr. Moss. Depending on how we get on, we may then also, Mr. Dodsley, see if we can fit your planning evidence in as well. That I think will probably be quite a good idea, because we're taking you out of order in terms of your closing on the Wednesday, and at least you'll then have just one job to do on the Wednesday rather than two. It all depends on how things go in terms of timing, but I'm feeling optimistic on this second week. I always feel optimistic, and then my optimism is dashed as we go over time. But there we are. Let's start off optimistic. Okay. Housing land supply. Mrs. Dodsley, you're welcome to join us and interrupt and take your say if you wish to. But as I think you probably know, it's a fairly dry subject. So, bless him, Mr. Fittock has decided to take on that challenge. So, thank you very much indeed, Mr. Fittock. I don't envy you. It's, even as an inspector, I find it a dryish topic. In fact, I tell Mr. Pycroft here, who's appeared before me many times, that sooner or later the government will get rid of this and he'll be out of a job. And I won't, I say to him, I'm not going to be at all unhappy with that, but I'm sure he'll find a new job somewhere. Okay, so let me tell you what I've got open. I've got Mr. Pycroft's proof and appendices. I've got Mr. Fittock's proof and appendices open. I have the Statement of Common Ground open, which I do find very useful. And I also have an agenda that was suggested by the main parties. I'm happy to use that agenda as the basis for our discussions this morning. Just to run through it, there's some various agreed matters, and helpful just to confirm those, see whether there's been any changes to what was agreed in the Statement of Common Ground. There's issues to do with definitions of what is the definition of clear evidence, or at least the definitions set out in the framework. And then there's a series of matters that aren't agreed. I think in the Statement of Common Ground there were 5 sites. I think that seems to have reduced to 4. You can explain to me why that is the case. And then we have some issues to do with calculation of small sites windfall allowance as well. And then if there are any other matters, we'll sweep up those at the end. Are you both happy that that covers everything that you want to discuss?
There was just a minor point from me, if I may, sir, on the local housing need. So when we exchanged evidence, the data sets that feed into the local housing need were the affordability ratio from this year, from 2025, but published this year in 2026.
So they're published in March, aren't they? normally?
Correct, sir. Yeah,
Okay.
and the housing stock data, which forms step one of the standard method, was published in May 2025 and related to 2024. That's since been updated, and it means effectively that the local housing need increases by just 2 dwellings per year. And I alluded to this as a possibility in the appendix 2 of my proof of evidence. I think it's probably right that we use the latest data sets, even though we obviously exchanged evidence and statement of common ground predated those data sets, because the PPG says use those data sets, and also happily they tie in with the 2025. You've got a full set of data for 2025, which is also our base date here for calculating 5-year supply. But what I propose to do, if you would find it helpful, sir, it's only a minor adjustment, but we just agree a table at the end of this roundtable session that picks up any changes on the supply as well.
Okay, so on the supply side, two things. First of all, the stock, housing stock was updated. You say May this year,
26th of May, sir, yeah.
26th of May. And then in terms of affordability, that ratio got updated. When did you say March?
It was March. I'd have to check, but I think that we used the March ones when calculating the figure at
okay.
exchange. It's just the housing stock
Okay.
that's updated.
Councillor Fitter, any thoughts from you on in terms of supply?
Thank you, Chair. It's a difficult one. I mean, I can understand what Mr. Pipe was saying, but the base date was from 2024 to 2025 and 2025 to 2027.
Yeah.
I don't think the problem was relating to the housing stock table 100B had been updated. There has been an adjustment to the affordability ratio because there is a time lag in the land registry and registry completion. So it does technically mean that the number for last year has been updated because of the affordability ratio. But that would have been in May of this year when the actual new tables were published.
Yeah.
Which I think I'll leave you to decide on that because that's running into this year as opposed to last year.
Yeah.
I'm not a technical planning expert. But
Yeah, no. But you make a good point. I mean, that's the thing that kind of sticks in my mind there, Mr. Pycroft. I mean, you're arguing, you are in terms of delivery, or what has been delivered. You're very keen on in your evidence to ensure that there isn't any updating of more recent data outside the base date. Now, why doesn't that also supply in terms of local housing need figure?
Yeah, so effectively, the two figures that we're talking about is local housing need calculated at exchange, which is 584 dwellings per year, and now, which is 586 dwellings per year. It's only a small difference, obviously, but the reason why it still goes back to the base date point, because that 584 figure assumes housing stock at 2024.
Okay.
Whereas even though it was published, as the council rightly points out, well, that's coming into this year, it was published in 2026, but it relates to the position at 1st of April 2025, i.e. the same base date that we calculate everything for. So completely consistent with the rest of my case, which is looking at what the position was at the base date, and then completions before that shouldn't be included, and also that was the need at that time.
Right. It's a relatively small change. As Mr. Pittick says, Councillor Pitter, I'll mull it. I don't think it makes a great deal of difference, to be honest. So, in the great scheme of things, it's not something I think we're going to die in a ditch on. Really. Okay. So it goes from 584 to 586, did you say?
That's correct, sir. If just a final point from me on it, if I may. So in that appendix to my proof, I referred to a couple of appeal decisions where this point has been looked at before, and inspectors have agreed yes. The latest date should be used because that's what the PPG says, and that aligns with the base date, which is the point that I've just put to you.
Though I'm sure if we all looked hard enough, we could find appeal decisions that went both ways, I suspect.
Take the point, but on this specific issue, no, it's been a relatively new issue arising from the new standard method,
Yes.
and I'm not aware of any appeal decisions
Yes.
that said we
All
should
right.
use it. Thank you.
Okay, so let us go then to item 1 on the agenda, which is greed matters. We have the statement of common ground. The base date you're agreed on is 2025, so that takes us up to 2030 for the 5-year period. The 5-year housing requirement is either 584 or 586, depending on how I look at the matters we've just discussed. You both agreed it's a 5% buffer, which is fine. And then you'll both agreed that a 5-year housing land supply can't be demonstrated. However, we do have a disagreement over the extent of that. So, as I understand it, based on figures, based on the 584, the local authority is suggesting that there is a 3.98-year supply of housing, whereas the appellant are saying that it's 3.54. Is that have I read that right? That's good. Gentlemen, I mean, it's a relatively, that's quite a narrow gap. I mean, I'm more used to kind of having discussions when we're about maybe a year or more apart, as it were. The appellant, the council was quite happy for me to consider a range, as I understood it. Why, Mr. Pycroft, do you think you need to press this particular point?
Well, that's probably one for the planning evidence in terms of weightings and how the witnesses will be inviting you to consider the appeal in the context of the shortfall. I think whilst there's only 4 sites and the small sites windfall allowance, I don't think it will take too much time for you to consider. You'll see what the differences are between us. But there is some wider context points as well that I wanted to raise at the roundtable session that I've covered in my proof already, that I think speaks in response to some of the points that were made in opening submissions and indeed in evidence in terms of the 5-year supply position changing during the course of this appeal application, and also what the future direction of travel is like as well. And you'll appreciate that within the context of the planning judgment, that they are relevant considerations in terms of scale of shortfall, and then also where the direction is likely to be heading.
Okay, do you want to do that now, or should we do that at the end, something more appropriate?
It depends. It's entirely up to you. So if you want to hear about the sites first, and then I don't think it'll take very long, either on the sites or the other points that I've said.
Let's pick that up at the end. Remind me if I start to close without hearing from what you say in those more general points. I think perhaps it would be useful for us to understand, well, for me to understand something of the background of some of the sites that we're going to be talking about before we get there. Okay, righty-ho. Right. Are there any other matters as far as either agreement or disagreement that either of you want to draw to my attention? Have I understood that part of the calculations correctly?
Yes, sir.
Okay, thank you. Well, let's move on then to item 2 on the agenda, which is the issue of definition, I suppose. Councillor Fittock, you perhaps are the man to start on this one, because having read your proof, you've obviously you delve quite deeply into the definitions in the glossary of the framework as to how one goes about identifying whether sites are deliverable and developable. And I think you have a particular point in terms of that definition. Would you like to explain that to me?
Thank you, sir. I mean, obviously, I'm not a planning professional. I'm looking at this from the outside and interpreting what the system says that we should be considering. And I did refer to the Sir Modwin's judgment, shall we say, where there was disagreement between the council and the appellant on two matters, which was the importance of the trajectory in the local development plan and how that, if you like, is related to the private housing landscape. And in summary, it was concluded that it wasn't associated, and there are two different measurements for two different purposes. And then obviously there's the question of what the definition of deliverable mean versus deliverability. And I think the inspectors, in summary, concluded that, the wording in the MPPF didn't explain what that meant in true sense. A bit like we've heard in the traffic data, what is the level of severe in terms of the number. So sometimes these things have to be clarified. Now, to me, the intention of the Lord Justice was quite clear, and they did set out quite clearly that the principle should be to demonstrate what can be reasonably expected to be delivered over a period of time. That we don't require certainty. And I think the problem that we're getting into, from my perspective, is that at what point in time does the burden of proof of evidence move us from a reasonable prospect to a point of certainty? This is measured in different ways in different industries. The courts might regard, for example, if they're looking at the prospect of an appeal being successful, over 50% prospect of it being accepted as a case is deemed to be a reasonable prospect. In my background, when we were putting business plans and proposals together, we'd expect 70 to 80% would be almost certainty. So I suppose I'm trying to turn the word into some kind of understanding of numbers in terms of probability. We can get into some advanced mathematics to work with this out, but I've tried to keep it very simple so that it can be repeated and so that officers can have a very simple process to follow. So that when we're producing private housing landscapes, it's not complicated permutations around it, but it's simple when do we think it will start.
Mr. Pycroft, deliverable doesn't have to be absolutely certain. That's what I'm hearing.
Absolutely so, and I agree with that. I'm not suggesting that there needs to be certainty, but what there needs to be for these sites in particular is clear evidence that there is a realistic prospect that housing will be delivered. And whether there is clear evidence, firstly, the onus is on the council to provide that clear evidence. When it produces its position statement, and indeed in this setting, in a Section 78 appeal, in its evidence before you, and whether there is clear evidence is a matter of planning judgment for yourself to make, sir. Now, what I've done in my proof of evidence in Appendix 1 is I've set out where the definition of deliverable has been considered by the Secretary of State and other inspectors. I found that there are certain themes that have arisen from those appeal decisions in terms of the type of evidence that's been provided and whether it's been considered as clear evidence or not. And I've appended as well 3, 4 and 5, so my proof of evidence, some of those examples where councils have provided, for example, pro formas with developers explaining when a reserved matters application is going to be made, when they expect that to be determined, when discharge of conditions applications are going to be made, when they expect those to be determined, when a start on site is going to be made, and then the subsequent build-out rates. And the reason why I include those is because I invite you to consider those cases. Oh, sorry, I should say. And even though we provided that evidence, that was rejected as being clear evidence by the Secretary of State and inspectors in those cases. But what we find is that the cases such as Braintree, the road provided much more than what Malden had produced in support of its position on the Category B sites. And when you compare the two and see that there is less evidence provided here, in my view, it's not clear evidence for the inclusion of those Category B sites in the definition. So it's not certainty, but it's a test of whether there's clear evidence. Thank you.
Okay. One other question, actually, then to you, Mr. Pycroft. Moden was, which is the legal case that Councillor Fittock is quoting. I think is about 2012, 2019. I'll beg your pardon.
If I may, sir, I think it predated the 2018 version of the framework and the change to the definition of deliverable.
Okay, I think that was the point I was just wanting to get your view on. Have events, or in terms of definition in the framework, has the definition changed since that judgment was handed down?
Yes, they have, sir, and for the reasons, as I explained in my proof of evidence, I see it as being a deliberate change to firstly split the categories of site, and B, to only include sites that effectively don't have detailed planning permission for major developments, only include them where there's clear evidence, and that followed directly on from the case law that the council referred to.
So the change to the glossary definition was actually a direct response to that particular case.
That's my
your understanding.
That's my understanding. Yeah.
Okay. Right. Okay. Councillor Fittock, any further comments from you as far as that?
Yeah, I mean, I agree that they might have slightly changed the glossary, but in the actual framework itself, it still said they need to deal with it.
It does. Okay. Thank you. Let's move on then to the matters that aren't agreed, which is now 4 sites plus the small sites windfall. Before we do that, I think there were 5 sites in the statement of common ground. Well, there's 5 sites in certainly Mr. Pycroft's evidence. The statement of common ground then differs slightly on site number 2, which is the Haybridge site, Great Tottenham Haybridge site. Can you just explain, was there some change in evidence agreement between you as far as that site is concerned?
That's correct, sir. So we exchanged evidence. The chain of events was we exchanged evidence and the statement of common ground followed.
Right.
And by the time that the statement of common ground was signed, it was agreed between the parties that that site was not deliverable, and then therefore those 22 units are not included in either of our figures. So the figures that you quoted at the beginning of the roundtable sessions are correct in terms of the supply. They don't.
Yes, I took those from the statement of common
Yeah.
ground.
Yes. Yeah.
Yeah.
So those.
Okay.
So that site's no longer disputed.
Okay. Would you agree with that, Mr. Councillor Fittock?
Yes, I couldn't find any evidence it was going to come forward.
Okay. Well, then let us then move to the first site, which is land north and west of Knowles Farm, Wick Hill. So that's here in Malden. Is that part of the South Garden suburb that's been built to the south, or is that not? It is it? You're slightly uncertain there, Mrs. Dodsley. Is it not part of that larger scheme? It is part of that larger scheme. Okay. Let me start off with Councillor Fittock. Perhaps you would explain to me why you consider that falls within the definition in the framework as a deliverable site.
In terms of evidence, I don't disagree that we haven't got one female. There is reason for that. There seems to be problems within the council in recovering any email against. We've had to sort of base the evidence is based upon our schedule that we've produced. That gives an indication of what historically has happened as a starting point. So our evidence indicates that when we look at table F69, that sites of this size will start 3.5 years after consent, which means it starts in, generally speaking, in the forms from outline consent. When I look at Litchfield start to finish, unfortunately it was supposed to be. When you look at their actual tables, although it's 4.6 years from outline consent, if we take that as being OMR, AMR, then that would then start. Our evidence lies with the same time. When we look at the application, it was consented to quite a long time, but there has been a delay in terms of the ownership of the land, in so much as the land was promoted on behalf of Manchester County Council, who sold it to a landowner. That landowner had then to agree with the price of the Manchester County Council, and that matter was resolved 7th of last year. The other side has been purchased by paper. So a starting point for our evidence would be that it would start that, if you like, is in line with it. Since that point in time, the developer is publicising on the website, its own website, and conducted a consultation with residents to get final feedback with regard to submitting a reserve application. The officers did get a pro forma response from the developer. It's some weeks back now, and that concludes that they expect to be on site in 2027, with completion starting from 2028, in line with our prediction. Their forecast is 60 units per year. Our average assessment indicates it will be 35. So we've actually forecasted a little bit less than they say they're going to do developing their platform. So I would stand by that. Whilst we might not have the email exchanges between us and developers, all of the evidence that we have, broadly speaking, it does point towards the original assessment. I have no reason to disbelieve the developers are wrong in their estimation when they intend to build and start building.
You mentioned the reserve matters; those haven't been submitted yet. Does the pro forma that's been agreed say when that's likely to take place?
Unfortunately, no, it doesn't say that. But if that evidence is all encompassing. In our assessment of the time from reserve matters to we're coming up with the year 2. There is no reason to believe that we so therefore I still feel there's a legal possibility. If it doesn't, certainly, at the very worst, would be pushed into I just answer.
Yeah, do.
I mean, part of the problem that we have is that obviously this is a relatively fast-moving situation, and the officers have opened up conversations with them, but they didn't at that point.
Mr. Piper.
Thank you, sir. So, just in response to what the council has said, not outline planning permission, the category B side, and the onus is on the council to provide clear evidence. My understanding from what's been said is that the evidence that the council relies on is firstly the average time taken for sites to start delivering from the outline consent. And I don't know if you got the councillor's appendices.
Yeah.
before you said, but mine seems to be in two parts, but it's the first page, electronic first page, the second part.
Yep.
And we can see that large sites included within that the first table, say 3.5 years, I think is what was referred to by the council in terms of the start time. And but what we can see on that table is there is a site at S2D that's had its outline permission in 2019-20 but hasn't had any completion before the base date. That's S2D press still 1.4. And my point is, once that's factored in, then that will extend the average lead-in time. You know, once that site starts delivering dwellings, that will extend the lead-in time as an average, because it's not included in there. And indeed on this site that's in dispute, the outline planning application was approved in November 2022. So again, that will extend average lead-in times if and when the site starts to deliver. The reason why I raise that is, yes, that's been the average experience on sites that have delivered, but there are other sites that haven't delivered that would lead to an extension of those average lead-ins. As I've put in my proof of evidence on this site, yes, it's got outline planning permission. When the council initially provided its draft position statement for this year in June of last year, it didn't find that this site was deliverable. It was only in February when it provided its latest draft that the site is included. It seems to be that the council has gone to the developer and asked them for information, but when you see the information that's being provided, which is on PDF page 4, that same document, an email that postdates the publication and approval of the draft position statement, and I think it postdates the first iteration of the statement on the ground where I was challenging the inclusion of this site. And effectively, all the developer says is that they expect to start work in 2027 and start delivering dwellings from 2028-29 at 60 per year. But what we don't have is any indication as to when a reserved matters application is going to be made, when applications to discharge conditions are going to be made, when they're expected to be approved, infrastructure put in place, and the sort of detail that you would expect to see on a large site. And as I raised in comments earlier, when one looks at the other evidence that the council much more detailed than this, but that in itself has been rejected as well. And this is further away from it.
Can I pick up on one point? Yeah, I mean, I hear your criticism of the figures that Councillor Fitchick has put forward as evidence of how build-out, the speed of build-out rates. But as a matter of principle, is it reasonable to take local data as being perhaps a better guide to build out rates, because one is looking at developments that are taking place in this district rather than averages that are taken nationally in the start to finish document?
Yes, I think it's fair to look at both. It doesn't mean just because you would look at one or the other. I think it's sensible to look at both and see how it compares. I think it is useful to have a look at local lead-in times and local build-out rates. But the reasons why I raised, you've got to look at the overall picture and not just sites that have delivered. You also need to take into account, what the impact of the lead-in times would be on sites that haven't delivered in accordance with that, haven't delivered any units yet. So as a raise with that Crest site, that would extend the average because it hadn't delivered any units by 1st of April 2025, even though it had its permission in 2019. Its lead-in time would be at best 6 years. And that isn't then factored into the average.
Okay. Would you like to respond to that?
Yes, sir. Yeah, I think that Mr. Pycroft's misinterpreting the table. If we look at the top of the table, it's a more than build-out lead time study for 1,000 plus units. Okay. So he's quite right that certain phases of that development, when Litchfields do their studies, they don't look at all of the individual phases and what. Basically, what that evidence is telling you, for a large site of 1,000 plus, the first development would be in year 3 from S2A, year 4 from S2. And underneath that, what we've done is we've calculated what the first year average would be, the all year average would be, and the full year average would be. And we pretty much other than the fact that we've got more detail, because we're trying to identify what we're doing here. So it's not appropriate to look at that and say that the average is correct. It's for slightly different size. On the table below, it's a study being put on 104. And they again have different characteristics. Because we're not looking, a phase is always going to be much longer.
Yeah, I only raised the 3.5 because that was what the councillor was relying on when he when he said we use 3.5 and it compares to Litchfield. 3.5 is from that table. If we look at sites of this size, the 104, 100 capacity with 499 dwellings, this site itself makes the point that I'm raising, which is it had its outline planning permission in 2022, 23. It hasn't delivered any dwellings. It's not even expected to on the council until 2028, 29. And that would be a 6-year, which would extend the average lead-in time that the council then uses for this block of sites. So my point is the same, which is, yes, please do look at local evidence, but one also needs to look at sites that had planning permission that haven't delivered any units as well.
Okay. And then my last question to you, I think, on this site is, Councillor Fittick tells me that part of the delay between outline and actually the site moving or starting to move was due to negotiations over the price. So the county was selling it, and I think you said Taylor Wimpey has bought it. But that has now taken place, and Taylor Wimpey are now the owners of the site. Is that a relevant factor here for me to take into account?
Yeah, yes, it's relevant because it explains why an application that was made nearly 11 years ago had still on a site has still not delivered any dwellings. That explains the history of the site. What it doesn't do, in my view, is advance things further from being a Category B site in knowing when that reserve matters application is going to be made, how long it's going to take to I raised earlier, irrespective of the fact that Taylor Wimpey are now part of it. One would expect to see that level of detail to support its inclusion in the private.
Oh, I see. Okay. But then again, are Taylor Wimpey really going to, now they've bought the site, they've committed their money, they're not going to just want to sit on it, are they? They'll want to get a return from it.
You wouldn't have thought so, sir, but the point is we just don't know. We don't know what their programme is, because all we know is there was saying, oh, we want to start in 2027. Well, is that realistic when a reserved matters application hasn't been made in 2026? We just don't know that detail. Things change, priorities change, sites change in terms of what the running order is for developers. But we're looking for clear evidence, and the position is unclear.
Councillor Fittick, anything from you, as it were, before we move on to another one? You said everything you want to say on this particular.
I think so. But all I'll say is that here we get into this problem, don't we? Is that the evidence is that the data shows that it will start within 2 years of reserve matter coming forward. We've got the developer publicly, if you like, stating that the developer's moving forward and they're working on their final reserve matters. And then we get into this, well, because we haven't got absolute confirmation as yet from the developer that when they're going to submit reserve matters, that it can't be included. Well, the problem we have there is that then we can't properly talk. But just because we haven't got certainty of the event doesn't mean say it doesn't happen.
That's okay. I understand that point. That's the judgment call element, isn't it? Okay. Let's move on then to site 3, which is land northwest of 2 Malden Road, Burnham on Crouch. Let me start with you, Councillor Fittick. Perhaps you could explain why you think this site should be included.
So this is quite a complex site, and I don't necessarily think that the way the data is represented makes it very clear what's going on. But firstly, I can confirm that we do have a reserve matters application for this site. I did reach out to officers and ask them when it's likely to be determined, and they have said that they expect it should have been in December of last year, but because the council has generally got pushed back, so I expect to be determined in June of this year.
Which is now.
The sites themselves are actually quite complex in terms of what they're made up of. And I think that they're both interrelate, because part of what Mr. Michael's saying is about S106 things. But if I explain quickly, the phase 1 of the data is actually 103 bungalows and 55 apartments, plus 8 independent living units, 8 key worker units to go with the shops that are going to be built. Site 2, or phase 2, is 132 bungalows and 100 apartments. So it's not 230 bungalows. Obviously, I'm trying to sort of understand how the officer reached the conclusion that they to start the fresh, and it's certainly, given that the reserve matters is about to be determined and was forecast to be determined by it's been sitting there for years. We would expect that developer to come forward based upon our findings of lead times in year 2 following the consent. So year 2 following the consent, if it's consented in 26, 27, will be 28, 29 in terms of start on site, which it complies with what the landscape showed. The 87 units are based upon the average lead time that the officers used for first year and second year. But it's likely to be a combination between flats and. In terms of when the site would start, looking through the conditions, the site can start once the 92nd market housing dwelling on phase 1 has been completed, which we would expect to be before that point in time that the phase 2 is like that. But going back to phase 1, the build out on that is probably slightly confused in terms of what the numbers are saying, because it will be flats and bungalows as opposed to straight. So I don't see any reason why that can't be done. And looking into it in a bit more detail, there was a challenge to the 5-year housing land supply by a company called Bidwells, and they indicated in their opinion that that site, or site one, would build out by 28, 29. So although any molecule actually says it would take longer. So the point is that I don't see anything that would preclude that development from starting at the time. And the numbers that have been used, albeit somewhat untidy, the way it's presented, 87 units between a mixture of 132 bungalows and 100 flats. Not really.
Bungalows and flats. Is it aimed at is it an elderly scheme?
It's a,
It's got an age restriction on it.
yeah, 55.
Mr. Pycroft, what's your concern on this one?
Yeah, so I think we're actually talking about two different parts of the site. So I'm afraid. So if you got access to core document L2, which is the position statement or draft position statement that we're working to from February earlier this year.
L2, yeah.
And on PDF page 17 of that document, you should see a table 7.
Yeah.
So which is large windfall sites with planning permission not allocated in the local plan. See the third row on that table, that is phase 1. It's under construction. I'll discuss that in a moment. If we then look at the next entry, that is a permission 22-00887 OUT. That is included in the council's 5-year supply for 87 dwellings. That's the site that's disputed. That site doesn't have any reserved matters application made on it. It's only got outline plan.
Sorry, I was making a note there. Just take me back once to there. Which line am I looking at?
Sorry, so it's core document L2, PDF page 17, and it's the fourth site.
Fourth site,
Which is
yeah.
22-00887
Yeah.
OUT, included for 87 dwellings. Up to date information says would require amendment to section 106, which again I'll come on to.
Okay.
But the point is that part of the site does not have a reserved matters application made on it, and yet it's included in the 5-year supply. And the site just below that, so the 5th site on that table, which is 21-00075,
Yeah.
is the one that the council has referred to, which has had a reserved matters application pending since early 2025, but is not included in the 5 years. It's agreed that that site is not deliverable.
Yeah. Yes.
The dispute is the one above that,
Yeah.
with no reserved matters application pending. And then in my proof, this is PDF page 36, hard copy page 33. I explained that reserved matters application hasn't been made. I explained that in the previous 5-year supply position statement it wasn't considered deliverable. And nor was it in the draft version of the current position statement last June. I explained that the comments on this site, which are back in L2 on PDF page 20, explained that it could come forward ahead of completion of phase 1, subject to an amendment with the section 106 agreement, and ensuring that the infrastructure is linked up, of which we've got no clear evidence that that is happening or is the case. And I also explained that on the phase 1, I think it's been discussed already that this is a retirement village, and it's not the sort of usual build rates that are experienced on other sort of general market and affordable homes elsewhere. And I explained that the build rate on that part of the site, the phase 1, was 1 dwelling in 23-24, 9 dwellings in 24-25, and then I know the the council's provided me with the build out rates in 25-26, which is our first year, and there was only 24 delivered. So all that in the round, this is the disputed site is a phase 2, which is expected to come forward in accordance with the 106 agreement after the phase 1. Phase 1 has had lower build out rates and has been delivered. No objection to the inclusion of that site. But it's not the site with the reserved matters pending, which the council's own document says is not deliverable. And again, we see that on PDF page 20 of L2, which is the 232 home scheme on phase 3. Site not started, no completions expected in the next 5 years.
Where do I see that?
So core document L2, PDF page 20, and it's number 5. The 3 phases are dealt with in 3, 4, and 5.
3, 4, and 5.
Thank you.
Okay, thank you. Right. Okay. Councillor Fittick, any response to the points that Mr. Pycroft makes there?
I think I'm getting confused here because unless I'm trying to find the paper in the report, the reserved matters application that's come forward is for phase 2 of the development. And phase 2 of the development is 132 Barnes Road and 100 flats.
So, as far as you're concerned, the RM for phase 2 is in.
Yes.
That,
Yeah, it's described as phase 3 here, sir, because we can see that with the 232 homes on that PDF page 20. Council's explained that it's 100 one type of home and 132 of another is the 232.
and 203. Any thoughts there, Mr. Councillor?
I think probably on the report it's probably listed the wrong. I think, you know, obviously it's definitely for the Gordon, but it's for
Whereas clearly down here that would be phase 3 rather than phase 2. I wonder, would you be able to check with the officers?
Yes.
On that? I wonder because whether or not it does or doesn't have a reserve matters is obviously material, I think, to how we consider this. I'll leave that one with you, but what's your response to Mr. Pycroft saying that with schemes which are age restricted, so aimed at elderly accommodation, they tend to have lower build out rates and lower sale rates than general market housing? He's saying that will affect obviously the number of completions because the developers will tie completions to rates of demand. What's your view on that?
So I wouldn't disagree with that, and again, I think that's the unfortunate way that the report's been presented in terms of the numbers. I mean, Bidwell's, when they did an assessment of the site, they said that probably 40 BPA would be less the bungalows, and that the independent living or the flats would be built in blocks. I think there is a problem with the way the data is presented in the report. However, I do think there is a reasonable prospect that 80 units could be delivered, either it be building as flats and or bungalows and or two-lot flats. We don't know, but certainly around that number is perfectly acceptable.
Right. All right. I think I've probably got as much as I need on that, other than the point I've asked you to check there, Councillor. Let's move on. Let's move on to site 4, which is land north of the Groves, Burnham Road, Latchington. Councillor Fittick.
Well, again, I mean, I think it's been agreed that the site can be delivered within 5 years. The question is whether it will be completed in 5 years or not. certainly I presented evidence recently, but albeit after a point in time where the site is definitely building out.
But this is the site you provided some additional evidence on, I
Yeah.
think, wasn't it?
Yeah.
Do you want to explain what that evidence is intended to show?
Okay, well, I guess, I mean, this happened very, very quickly. I mean, it happens to be in my ward. 3, 4, it doesn't affect me, but sort of, I pass it every day, so I can see the effort going on.
Yeah.
But it really started extremely quickly. I think we given them reserve back probably in February, and by March they were on the site. So it's racing much faster than imagined. And obviously, I then established from the construction management plan that they intended to be a 114-week build-up as well. So again, going back to what our average build-out rates are, we're averaging 61 units per annum. Based upon the trajectory that we had, it would complete within 5 years. That coupled with the fact that developers would actually saying themselves they want to complete the site within 114 months. I would say there's
114 weeks.
114 weeks.
Yeah.
There's very good evidence to within 5 years.
Okay. Mr. Pycroft, and obviously bearing in mind the evidence that's been submitted most recently.
Just respond to that, if I may. So you've got my points in the proof, which are effectively, yes, it's got its reserved matters approval. I accept its deliverable sites. I've referred to some at paragraph 8.33. The council has referred to other sites in terms of the lead-in times. And in my experience, generally, sites of this size take about a year from their approval of their full consent to the delivery of units on site, the actual completion of units on site. That's not unusual. It's not unusual to see a start on site made in this time. We're in June now, 2026. So yes, they've started on site, but in terms of those actual completions coming forward, that is not unusual. That's what the photographs are showing in my experience. In terms of the construction management plan, yes, it says that they plan a construction period of 114 weeks. But again, that's that might be optimistic given experience on other sites, as you've seen with the build rates and the lead-in times for delivery. And in response to that, I know if we look at the councillor's appendix on PDF page 1, part 2. I tried to have a look at a similar sort of size site. I looked at the west of Broad Street, which is in the second table. It's the 5th site down. You can see from there, sir, that it got its full permission in 2016-17, and it started delivering in 2018-19. But the construction management plan for that site said it was going to start in May 2017 and finish in December 2019. So my point is there's no harm to them putting that in the construction management plan, but it's not the latest position from the developer. We know that this authority has gone out to developers and asked them for updates. We haven't got anything from Dandara other than their the extract from the web page when they took the site on when it had only got outline planning permission. That's on PDF page 6 and 7. The council's appendices. And in response again to the latest evidence put forward, you go on Dandara's website, they're not even advertising the site. There seems to be an expectation that there's going to be homes completed in August, according to the council's evidence. But one would expect to see in June them advertising the site. There are other sites in Essex that Dandara are working on that they are promoting homes for sale from plot in advance, or when the sales area is going to be developed. We haven't got that information. Thank you.
Dandara isn't a name that rings a bell with me. Are they local to Essex or any idea?
I think they're relatively new to on the block, but yeah, they've got big growth ambitions for this region.
That's entirely fair. They've got sites elsewhere, and I did get this work, and they're I'm familiar with them in this locality.
Okay. All right. Well, I've heard your scepticism based on your experience of other sites such as this, Mr. Pycroft. But also, obviously, I've heard what Councillor Fittick has been told by the developers themselves. Councillor.
I'd just like to come back with one point, sir, and that is that the site has got 50% affordable housing.
Why? Yeah. Okay. Well, why would that affect?
Well, I mean, when you look at the Litchfield, I mean, obviously it's not the document, but I can say is that what Litchfield's studies indicate is that areas with affordability above the national average end up with tend to have higher build-out rates. The level of affordable housing increases in the speed of build-out. And obviously one of the most obvious ones is that it's a greenfield site that was ever so easily repaired. It was done in weeks because it was in the field. It just levelled in and off they go. So although we've got averages, I would fully expect this site to exceed the averages based on the composition and development stuff. But we'll find in time.
Okay. Thank you for that. Let's move on to the last site then, which is site 5, which is land to the rear of 9 Church Road, Wickham Bishops. Councillor, perhaps you could explain to me your view on that one.
Thank you, sir. I mean, again, you know, we haven't unfortunately got much in return, although we've reached out to developers and asked them what their intentions are. They haven't responded, so then we're left with a situation of do we just say it's not going to happen, or do we try to forecast to the best of our ability what we think will happen? And certainly the evidence that we put forward indicate that this site would start in year 4 and it would complete in year 5. Have we got all of the email exchange of communications? No. But I would just like to say is that it's if we look at this as starting what has been a forecast, really what we're trying to do is to evidence that forecast to give it greater certainty. Because at the end of the day, if none of these developments in the past had any communications at all, the numbers to equal the numbers that we've got. And again, we're fairly in compliance with which to start to finish on that. So I guess I burden is upon you to something or not. We need all of these details to be assured of what's going to happen, or we can actually reasonably use the data that exists, which most other organisations would do in terms of making decisions, or we have to have this high level of certainty as indicated by the indicator.
So it's got an outline permission, but it has no reserved matters as yet. No reserved matters has yet been submitted. Is that correct?
That's correct. So the only thing I could establish is the land has been sold subject to contract.
Mr. Pycroft.
Thank you, sir. So, yeah, a site with outline planning permission, category B, no reserved matters application made, no evidence of progress being made on a reserved matters application, and I think it sort of sums up the position between us, which is council says, well, we've got sort of average lead-in times that we apply to sites, and my approach, which is, well, you need the clear evidence for the inclusion of the category B sites as per the appeal decisions that I refer to in my proof of evidence and the definition and the associated guidance in the PPG. Thank you.
All right. Thank you for that. Let us then move on to the last matter not in agreement, which is to do with the small sites windfall allowance. And on that one, Again, I don't think there's any disagreement between you that a small size windfall allowance is reasonable to include in 5-year housing land supply. It's just the extent of that windfall allowance. Councillor Fitting, may I start with you as to why you think it should be to put down on the same common ground as just 138?
The officer in the original calculation took a fairly simple way. It was a very simple way of identifying what he expected to come forward, and it was on average 2.5 years for a windfall consent to be completed. So the calculation was the average number of years of windfall times 2.5 to 138, I think it was. I wasn't entirely sure that was a very good way of calculating it, so I've looked at it in various different ways, looking at the forecast supply over a 5-year period, the minor completions over a planned period, and then I worked out what the average of each year consent would be, and each one of those came to around about 139. That was in the
So that's how you've looked at it. How's it done in your annual monitoring report?
I wasn't entirely sure it was a very good way of doing it. It was done by taking the average per year, and on a 2.5-year average, it would equal 140, 138. But it just so happens that whether it's luck or judgment, that is actually what it comes out to when you look at it in very different ways. I think probably the best way, if you were to look at where I've looked at on at the end, the amount of consents that will be contributed each year, and we can see in year within 1 year is 3.05% and so forth.
Just where are you referring me to there?
That's page 64, I think.
Hang on.
Yeah, I mean, this would probably be my preferred way. I've looked at the percentage contribution by year from a development, because obviously what we've got to do is decide if a development was consented to now, what contribution it would make to the year within 5 years. So when I do that progressively, I can see that I'm trying to establish, for example, what contribution years 4, 5, 3, 4, 5, and so forth. So when I work through it, I can see that 3.505% of development is actually completed in the same year on average. Yeah. And then we move up to 22.37 and so forth. So by doing that, I can then calculate the individual contribution of each year as it moves down. So obviously you see the percentage stuff, but that one will complete. Yep, so I'm working progressively through the amount of contribution for each year as we move forward to 5 years of contribution.
I understand how you've worked it out. Here's my question to you. Is there a degree of double counting in that? Because if a detailed planning permission is granted for, say, a house or a couple of houses, that would be a category A permission as far as the glossary is concerned, and it would already be included, I expect to be included in the calculations. Typically, it's kind of only and so with the planning permissions, which typically have kind of a 3-year planning permission period, that's the period you've got to implement your planning permission in. It's only after that period that, as it were, a windfall might become. You can maybe count windfalls because they aren't part of your known category A detailed planning permissions.
Yes, so you're quite correct, but this only relates to minor windfalls.
Yeah.
Under 10 years.
Yes, but I mean, for something that is granted a detailed plan permission now, that should be included because it's a detailed plan permission. It's in category A for clustering, and you can include that in your supply agreement once that your officers have done that.
Yes, sir, but that's what this is trying to establish, is that from new consents that are granted, what will be the contribution on average of rent?
Yeah.
So this is basically looking at the average that we would if we look at the average level of windfall, then on average 3.05% of those complete. So as we consent each year between now and the next 5 years, 8% of that will likely be delivered within the 5 years.
Yes. Okay. And Mr. Pycroft, you obviously take a different view. What's your concern?
Yeah, so section 10 of my proof of evidence PDF page 45. I think it's relevant here to note that this is the first time that Malvern has included a windfall allowance in its 5-year supply compared to the last few years. So we're in sort of new territory here. This isn't something that was established at the local plan examination, for example, and then is just rolled into every 5-year supply. I think what's happened is the council thought, well, have we got compelling evidence to include a windfall allowance in addition to small sites with planning permission? I accept that they do, that there is compelling evidence, but the way that I've got to it is I asked the council to provide me with its past completions, and it did that, and that's included in the table on my PDF page 45, and that shows an average of around about 60 per year are completed. And if you expect 60 per year over the 5-year period, it comes to 360.66, so it comes to 303. This is my paragraph 10.5.
Well, hang on, let me just get that.
Yeah.
Yeah, 45.
Sorry, just scroll over onto PDF 46, paragraph 10.5. Explaining that what I've done is I've looked at the average completion rate of around about 60, which I think is consistent with what the councillor has got in his PDF page 64 that we were just looking at.
Yeah.
Times that by 5, removed from that the 194 dwellings with planning permission that are already in the supply,
Yeah.
and that creates what the windfall allowance would be. It's quite straightforward, but based on what the framework is asking us to do, which is looking at the historic completion rates, to give us further comfort of that, we can see that over the last few years, build rates have actually been 51, 51, 59, 59, and then in the 25-26, which admittedly is our first year of the 5-year period, we know that the completion rate is 43 on small sites, because the council provided me with that completion rate. So they are, yeah, which is the approach that I've used, but it's not, if it had shot up again in this last year, then that would be to take into account the fact that it's going down. Probably suggests that it's a conservative approach. I refer to another appeal decision where this approach.
Yeah. Okay. So I understand where the difference comes from now. It's a difference in approach and calculation. I'm okay with that. I understand that. Councillor Fittick, you're looking puzzled there. Do you want to respond?
Yeah, just one thing. So, I mean, Mr. Pycroft says that we've not had a windfall. In fact, we did have a windfall. It was up till 2019 to 2020. In terms, there are two different allowances, aren't there? There's the allowance in the local development plan, where you evidence what you like to type of windfall will be. And then there's an allowance in the 5-year housing as plan, which looks upon historic trends. Now, we did start off with a windfall allowance of, I think over the first few years, of 750, 225. We had a change of methodology adopted the same period of time that we lost our 5-year housing act by 3.26, where the officer took out the windfall. And if I'm honest, it's because of the confusion about what the windfall allowance represented. It doesn't have to have evidence of supply as far as the local plan is evidence of ongoing supply. So it has taken a couple of years to understand what we should be and what that we can apply, and that we don't necessarily have to have a policy that facilitates that. The policy is
Okay, I think I do know what you mean. Yes, in local plans, this comes up where a situation where an authority hasn't had a local plan, and therefore quite a lot has been granted on appeal. And the question is whether or not that historic supply would continue going forward once you've adopted the plan.
absolutely so. And that was where the
That's
confusion
the
was.
issue. That's where it's gone wrong. Okay, I got you. Good. All right. Well, I understand the differences in calculation. I'll have to give that some thought. Okay. Anything else as far as the sites or the small sites Wimford is concerned? Okay. Mr. Pycroft, you mentioned at the very start that you had some kind of general points that you wanted to make. Do you want to make those now?
Yes, if I may, sir. So it's just 3 points of reference in my proof of evidence, if I may, in response, I think, to opening submissions last Tuesday. So the first point made was, I think there was a feeling that the council has just not been able to demonstrate a 5-year supply since the new standard method came into play in December 2024. And just for your reference, beginning of section 5, PDF page 22 of my proof of evidence, I explained that there was a 5-year supply found on adoption of the plan in June 2017, but in the following 3 years there wasn't a 5-year supply at that time, even against the lower adopted housing requirement figure. Then there was a 5-year supply in 1st of April 2023. That was against the former standard method. No 5-year supply in 1st of April 2024. And the current position, as we know, so effectively in 5 of the last 6 monitoring years, there hasn't been a 5-year supply. Rather than it just a sort of feeling that it just changed overnight. Part of the reason for that, as I explained in my proof of evidence same section, is because in the previous section, section 4, it's because the adopted allocations didn't come forward as we predicted in the local plan. So it's not an unusual circumstance where a plan gets adopted, finds a 5-year supply. Actually, the local plan allocations, particularly the large ones, take longer to start delivering, and then that's why the 5-year supply fell, but was propped up by, as I do come on to in section 5 of my proof of evidence, that you just raised, so about windfall sites coming forward, the large windfall sites are coming forward, so it's something that was raised in opening by the appellant, which was actually the supply would be worse if large windfall sites hadn't come forward. And indeed that, as I explain in section 6 of my proof of evidence beginning on page 27, is part of the reason why the supply has improved compared to the 2.7 at the time that the application was this appeal application was considered. Rose 4.1 in the draft now counts as 33.9, mine 3.5, because as I explained in that section, in fact there were three large sites that were approved, large windfall sites that were approved at appeal, and they are listed in my paragraph 6.8 on PDF page 28. So my point is, yes, the supply is improved, but it's actually improved because, in part, large windfall sites have been granted permission at appeal.
Or approved by the council. There have been a couple of things.
There has, and I refer to those in this section as well, albeit in my table 6.1. The text that surrounds that. Actually, there hasn't been. There was only 2 large sites that were approved by the council in between the position at 2024 and 2025. The quantity in terms of numbers of homes has come from so and in fact on one of those sites there wasn't it didn't lead to a net increase. So the only site that did was a site with 63 dwellings, of which part of it was allocated anyway. That's the second site on my PDF page 30 versus the numbers that you'll have seen in my paragraph 6.8 that were approved at appeal. And then the only other point that I wish to make, sir, if I may, is the sort of direction of travel. So I've already referred to the fact that the council's provided me with the completions data for 25-26, and there were 445 dwellings completed in our sort of first year, which is broadly what the council predicted in its position statement. It was a little bit less, 437. The 445 were completed in 25-26, but if we can turn up core document L2, we see that is not being replenished by sites that are going to come forward in our year 6.
Hang on, let me just get that.
So if we're on PDF page 10 to begin with, these are the allocated sites that are included in the 5-year supply.
Yeah.
And what we know is that from that first year, on all sites allocated and windfall, 445 are going to come out of the council supply when it updates its position. But coming in at year 6, we see that actually the first 2, 3 says that the site will be completed within 5 years. There may be some on that fourth site that we've discussed already at Knowles Farm. Then the following sites all completed within 5 years. And throughout most of the allocations, vast majority of allocations are expected to be finished before 2030. And that's the same pattern as we scroll down PDF page 17. That deals with the windfall sites, with very few that are actually expected to start delivering beyond continue to deliver beyond our 5-year period, i.e. that 445. The evidence is pointing to the fact that isn't going to be replenished by other sites or parts of sites that are coming forward later. And what that means is that whether it's 3.5 or 3.9, one would expect to see the supply decrease when the council publishes its next position statement, unless, of course, additional sites are approved and they're deliverable.
Okay. So, Richard, do you want to say anything on those points that Mr. Pycroft made?
I mean, I think it's their comment that we're obviously in a situation because all of a sudden the target changed and we haven't planned for it. So yes, we will need to consent to developments in order to bolster our private housing developments moving forward. That goes without question. The question for us all to answer, members to answer, is we need to be in the right places where possible. Because obviously that's what we need to do. It's not easy to go the right. We have plenty of potential supply coming forward. And I guess this will go back to the how when we can demonstrate a 5-year housing land supply to a large degree determined by whether we have to absolutely evidence all the things that I think will happen. But the data says will happen. Because if we do, then we end up with problems. Just to go back to what Mr. Pycroft said, one of the problems that we experienced in the past, which directly relate to when it got to 3.26, was how we forecast what our future trajectory will be. If you take the approach that, well, we can't include it as a part of our land supply because we haven't got the reserve land application yet, then you end up with this tsunami effect, which is what we saw. So because the officer didn't have the evidence to include that development a higher build-up rate, it was forecast to build out 50 units per year for 24 years. This is the site of 1,200 houses. And then the same happened in 2023, which when we moved to 2022, we moved to 3.66. Then all of a sudden it shot up to 6.35. So the point I'm trying to make is that I understand all of the guidance, but if you're trying to forecast where you're going to be, which is what the private housing is supposed to be, there has to be some element of sensible analysis. And the fact that we couldn't evidence that it's going to come forward because it is not reserved application doesn't conclude in the real world that actually happened, and it did happen. And whereas we said that we was 3.26, it was a lot more. I mean, and Mr. Pycroft mentioned that things have changed. And yes, they have changed, because when we looked at the reasons why we've got this instability in the private housing land supply, normally speaking, what organisations do, they go back and look at decisions made and see how active they were. So when we looked back and looked at the land supply position in 2029, it was 96% active. When we looked at 2020, 99% active. When we look at 2021, that calculates to 63% accuracy. So basically, we built 1,980 houses, and the forecast completions was 1,256 houses. So that is using a completely, if you like, evidence-based approach to making sure all the I's are dotted and things are crossed. The net result of that will then be that you don't actually plan for the correct number of school places that you have in the district, because this data is used by Essex County Council to forecast school places. I know, because I've looked at it, the forecast that the County Council were using over the previous years for that development was 50 units per year. And then this translates into the local housing needs assessment agents say that there's oversubscription school places. So this is almost like a circular argument. So I agree that there has to be reasonable amount of evidence and what the MPP is implying, but if we're not able to actually accurately forecast, then what's the point of the purpose of the document in the first place?
Okay, no, that was very much the point you started with, and I understand where you're coming from. It's the issue to do with what degree of certainty does one need in forecasting the supply. I understand that. Okay, thank you for that. Good. Okay, I think I've heard everything as far as our agenda is concerned, and we've heard your broad points, Mr. Pycroft. Is there anything either of you want to say left in terms of 5-year housing land supply? I have some issues to consider. There's one point of clarity. I'll leave that with you, Councillor. But otherwise, thank you very much. I'll call a halt to that particular round table. Where are we? We're 11:05. I think it's probably time for a break. Let's take 25 minutes. We'll adjourn until 11:30.
So just one housekeeping matter. You'll recall throughout the transport evidence, there was discussion of the bus contribution being for 4-year service, and there was some question about that. In preparing for the SIL and roundtable obligation, Essex clarified that they did in fact mean it's a 5-year service, not a 4-year service.
Oh.
Yeah. Seems to have been crossed wires at their end. We'll get an email, something so that it can go in. It took us by surprise. I imagine it's taken Mr. Wheeler by surprise.
So they're not asking for more.
No, they're
what
saying the
they-
850k
okay.
has actually been calculated for a 5-year service, not a 4-year service. So, obviously, so I thought that's something of which you should be made aware, and
Thank
we
you.
will.
I do think I should be made aware of that. So thank you. for doing so.
We're triple checking
Yeah.
because it seems to be a bit of a change, but the likelihood is that is right, and we'll get an email confirming everything into the core docs and provided to you if there's an objection.
Okay.
That's just reminding me. The other point being, if you have time in the break to ask the person.
I shall bang him an email. Yes, I shall do that. Thank you for reminding me. All right. Okay. We'll adjourn until 11:30. Thank you. Everybody, 11:30 and the inquiry is resumed. Housekeeping matters.
Sir, thank you too. I have here a printed copy of the Highways email given it to the other parties.
Yep. So if I can go up onto the your document website, that'd be helpful. I'll get a number 10.
I think this is 11, sir, because 10 was the documents that Mr. Pitt introduced the photo, wasn't it?
That's absolutely right. Yes. You just do you want to just give me some detail of what this email shows?
So yes, I've just given away my copy to go and be uploaded, but in effect, we reached out to Highways ahead of the Section 106 session because somebody who'd been doing conditions and obligations had watched the cross-examination of Mr. Bancroft, noted the 4 years referred to, and had been under the impression it was 5 years. So he reached out and said, "Is it 4 or 5?" And this is the response from Highways, which effectively says, no, 850k is a 5-year contribution. In broad terms, they looked at it, explained the justification, including not thinking that the current bus service is a reasonable provision. I'm paraphrasing because I don't know. So that it explains why it is 5 and that the 850 goes to 5. So that's all that is. The second housekeeping matter, sir. Miss Dodsley's heard back from your case officer, and apparently he can't get access to.
Yes, I got
appeal
a
reps.
reply from him. He seems as surprised as we are. He thought they had gone. So I don't know whether it's a computer glitch or some human error, but he says he's trying to get that resolved as soon as he can. So I'll update you as soon as I have something to say. There weren't many from memory. The only one I think that, as I say, I do think well, certainly the appellants need to be aware of is one from the NHS, which was seeking a higher figure to the obligation because of construction costs or something along those lines. So they'll come to you as soon as we have them. Okay. Any other housekeeping matters? No. In which case, let us move on to what we call general planning matters, but there's a variety of things here. There's an issue that was raised by the Rule 6 party, which relates to the spatial strategy of the local plan and the extent to which the site does or doesn't accord with that. There are also more general planning matters that both main parties have addressed, and that includes such matters as the local plan policies that may be relevant. I flagged up some relating to landscape, which I'm sure you'll pick up in due course, and also matters relating to the weighing of all the various factors that we have before. The first witness that we have on the stand is from council, that's Mr. Moss. Mr. Grant, over to you, please.
Thank you, sir. And I will do as you've indicated with the other witnesses and take Mr. Moss's proof as read. So we'll be asking him to highlight and supplement it points as required rather than go over them, if that's all right with you, sir.
Certainly.
Good morning. Just Mr. Moss. I'll introduce you. You are Martin Alexander Moss, Chartered Town Planner. You hold a BSc in City and Regional Planning from the University of Wales, Cardiff, and a postgraduate diploma in Town Planning, which you got from the University of Wales, Cardiff. You were employed by Bell Cornwell, LLP as an associate, and have been there since May 2023. And you were at JLL from Lord Jones LaSalle, to give it its full name, from January 26th to 2023, and a planning consultant at Geraldine before that, and RPS before that. So you've got 20 odd years of experience as a chartered town planner. You've dealt with planning applications and appeals relating to both large scale and complex developments, including development of greenfield sites. Is that all correct?
That's correct.
Brilliant, thank you. You've given us a proof from which I was reading, as I've just set out. I won't ask you to repeat the points of that because that can be taken as read. So really the focus of this evidence is to pick up any additional points you want to pick up, highlight key points or respond. So first question, please, is are there any errors or errata in your proof that you wish to inspect?
There are 2 minor errors. On paragraph 310, where I refer to policy S2. That is, of course, a policy referenced in refusal reason 2. It isn't referenced in refusal reason 3. It is simply an error purely in that sentence. It's not reflected in the rest of the proof. And then on page 10, in respect of the benefits schedule, I refer to appeal Q22. I identify that as having 10% provision above affordable housing policy. In fact, that was the case at application stage. The appeal was determined on the basis of affordable housing being 20% of policy requirements.
Sorry, which paragraph were we talking about?
So
there?
this is my benefit schedule on page 10.
Yeah.
On page 28.
Sorry, that was on my PDF.
Ah.
My benefits table.
Thank you very much. So policy matters first, please. You set out policy compliance and some general weightings in your proof. I don't ask you to go over that, but the inspector did specifically ask in the landscape session to pick up, please. I think it's H4 and D1, isn't it? So those were the two that you specifically asked about. So can you please outline your views on H4 and D1?
So obviously, I'm mindful that this is an application for outline planning permission with matters reserved. However, policies D1 and H4 are listed in the refusal reasons. I read part 1 of policy D1 as relevant to proposals, and the proposals required to be in compliance with it. This states that all development must respect and enhance the character of the local context, and make a contribution in terms of a number of criteria. That's relevant to its outline application in terms of landscape setting, townscape skylines, historic environment, and obviously the height, form and massing of the buildings insofar as building heights are identified in the parameter. In terms of policy H4, now this isn't a detailed design policy. It isn't one that requires strict compliance. It seeks for all developments to be design-led and optimise use of the land, having regard to a series of considerations. I consider that insufficient regard is had to those considerations, in particular the location and setting of the site in terms of its countryside separate from the town, character and density of the surrounding area, accessibility, which we touched on, and the capacity of the road network specifically in terms of the local infrastructure.
So you do think they're both relevant?
I think they're
parts of it.
indeed.
All right, okay.
Thank you. That's all I was proposing to ask you to pick up on substantive compliance with the development plan policies. Unless there's anything you want to say additionally to that? If not, we'll move on to their consistency with the NPPF.
No, nothing further.
All right then. We know that Mr. Wheeler makes a number of points about consistency of various development plan policies with the NPPF. So, defend our local plans. Honour Mr. Moss. Why is it consistent? Or in your view, is it consistent? Sorry.
I think yes, indeed. In terms of landscape, policy S2, it's compliant. It's a positively worded policy. It isn't stating that the landscape should be protected at all costs, as insinuated in the appellant's proof. SA provides an overarching approach to protect landscape. I accept that in respect of development outside of the settlement, that there is a conflict there under paragraph 11 of the NPPF, but in terms of the overarching approach to landscape, that's fully compliant. And then obviously D1F, with respect to landscape, it says that development must respect and enhance the environment. That is a general policy. It was found to be compliant with the NPPF in 2012, and the approach, paragraph 7 of the 2012, paragraph 17, apologies, paragraph 17 of the 2012 NPPF. That approach is broadly the same as paragraph 7b, the current NPPF. So I consider that it does comply with the NPPF. In terms of heritage, paragraphs 135 to 3 of the MPPF. So consider as before, policy S2 is positively worded. It doesn't require full compliance in terms of sort of protectable cost provision. In respect of policy D1E, we'd like to respect and enhance. I do concede that the enhance element is a degree of conflict, but I would refer more to policy D3 as providing a specific detailed approach to heritage assets, and in that regard, that is fully compliant. Furthermore, in transport, paragraph 35, seeking for development plans to set out contributions from development coming forward in the local plan. The policy, the site isn't in the local plan. The policy makes specific reference to 278 works to mitigate impact from development. A point that Mr. Bancroft accepted it was reasonable to consider an approach in terms of impact on located sites, and my view in light of the evidence SLAC is that this would allow for mitigation measures to be provided accordingly. And then in terms of amenity, although that's not part of the council's case, part 4 of policy B1, the reasonable expectations and protection of amenity is consistent with paragraph 135 of the MPF in terms of the sequence of maintaining a high standard of amenity in existing.
Thank you. So that's all I wanted to touch on in policy. Before we get to benefits and potential detriments, there's been a number of points made about potential or otherwise sustainability of location. Mr. Slack conceded compliance with MPPF paragraph 110, in that it either is or could be made sustainable. What's your view on sustainability?
Well, sustainability is relevant to the proposals in terms of the knock-on impact in terms of transport impact on the highway. Now, there are clearly improvements that are going to be made that are going to improve the accessibility of public transport, but I consider these insufficient to reasonably persuade people away from the car. Car use will be predominant on this site, and that is then what causes the highway impact.
And conscious of trying not to ask you to stray into highways evidence because we've had that. But a number of points were made about the role of this site in both the local plan, when it was being adopted, and the Sheila, the next local plan. And I think it said in opening this has been earmarked for development for quite some time. So can you pick up those particular points, please, from a planning perspective?
When we're talking about earmark, we're talking about principally allocation. The site has never been allocated. It was promoted as a reserve site in the event allocations would come forward, and it didn't even make it past the draft stage. That it was removed at the request of the inspector before adoption of the plan. There was a sustainability report that actually assessed the proposals after they'd been put forward. At the request of the inspector, which identified infrastructure impacts and potential issues with specifically highways impacts combined with the committed and allocated sites within the local plan. So it was removed for that reason due to concerns being raised about transport highway impacts and in combination with the other strategic sites.
Am I right in thinking it wasn't actually allocated, it was safeguarded?
It was
a different matter.
Indeed. So it was identified as a reserve site in the event that the allocations didn't come forward, but it didn't even make that into the adopted policy, and it wasn't even assessed in terms of sustainability before. That is covered in the rebuttal to the transport.
So the just to core doc ref, the sustainability appraisal referred to as CDJ 22.
Expected.
So that's extant local plan and how the site featured that. What do you have to say about the sheet?
In terms of the housing and economic land availability assessment, that's an early stage preparative document from 2023. There have been other appeals for limited weight. It hasn't been through the scrutiny of the local plan process, and also it identifies housing up to 17,000 homes identified in there. This is one of those, and it's a wider site identified as well. It's a very large site. It extends well up to the boundary of the bridleway. 128 hectares, and with that 1,800 homes, there is potential therein to consider sustainable improvements in terms of bus routing through that larger site, in terms of primary or secondary school, in terms of care home. They're all identified as potential development as part of that wider development. So it doesn't, it's not a direct comparison, and also it is a very early stage and not being late.
Is there anything more you wanted to say on sustainability and how the inspector should weigh what the question is on that, and then how the inspector should weigh it in the balance?
I mean, I guess the questions that were raised previously was can the site be made more sustainable? I think it is going to be made more sustainable. I think the bus improvements that we've discussed and are going to help with that. The crossings are going to help with that. But I don't think it's sufficiently sustainable to dissuade people from their cars, which in turn means there is the highway impact from the cars due to the capacity issues discussed by Mr. Swart.
Thank you. Benefits, please, and we'll take them in the order in which they are in your table. Again, no particular need to repeat anything that's in there, but what benefit to report do you report to the provision of housing, knowledge benefit in this case, and why?
Consistent with recent appeals in this district, I apply significant weight to the delivery of housing. We've seen when this supply was identified to be 2.7 years. The most recent appeal, land Westlands Purley, which is Q23. The inspector afforded significant weight, and we've seen other appeals where it was afforded significant weight also at 2.7 years, including Q22. This is east of Haybridge, a more similar scale of development for 281 homes. So my view is consistent with what's already been demonstrated in the district with a lower supply of housing.
And I suppose just on that point, obviously you've got your semantic scale now. None. Not every appeal inspector may well be adopting the same scale. So your views on why you think you are consistent, at least because of the decisions.
They have adopted the same scale from very limited, some or limited or small. So it's the same category. Moderate, significant, substantial, very substantial. They have adopted that, and more recent decisions have been set in the context of those scales for consistency.
Your proof picks up and relies on council physics evidence 3.98. It's by your view, if the inspector considers Pycroft entirely right, 3.54 or somewhere in the middle?
my view as set out in my proof is based on the consistency with the other appeal decision, based on my understanding of other appeals against the WD. We're not talking about a massive shortfall. It's not less than 2 years. It's not now less than 3 years. There's been a marked improvement in the housing land supply position since it had to be addressed. I mean, it came in December 2024, and there was an immediate shortfall. It hasn't been that much time since to address it, and now we're at least 3.5, and we're so much higher than that. I don't consider the difference between the parties as any influence in terms of the rate of liability. Again, consistency really, where we've got appeal decisions in the past for most recent, sorry, for Q23, where we've got policy compliance, they applied they applied basically significant weight, where provision was 10% over in the appeal Q24, Southminster, 10% over, substantial weight, and correcting my error earlier, in the case of Q22, east of Broad Street Green, Heybridge, there was 20% over provision of affordable housing on that site, and therefore the inspector determined it's reasonable to apply very substantial weight. So looking at that scale that's established for us, I deem it appropriate that just a policy compliant provision of affordable housing should be afforded significant weight.
The nursery, please. Your views on that and why?
So the nursery, I mean, it's just land for a nursery. It's 0.13 hectares of land. That is far more than what is needed from the developments. There's 29 spaces for early years spaces development will generate. Refer to the committee report, basically in paragraph 5.152, that's C8. The county council state there's no need for this facility. At paragraph 5.17 of the same committee report, they note that it may not attract interest when marketed, and it's relevant to note that the developer has agreed to pay a contribution to early years places, equivalent to 24.7, which is generated by the development. So there's clearly a risk that this might not come forward. I think we might, therefore, I still consider it potential for this to come forward to be afforded moderate weight, but we might look at the appeal decision with respect to Q21, where a private nursery that was no guarantee of being delivered as a private facility was only afforded some weight, which equated to limited weight on their scale.
So I think, just to be clear, you just said in chief you would accord it moderate weight. Your proof as provision of allowed down the nursery is significant weight.
Sorry,
so
I brought it down to moderate. So it's significant. I think we would look then at moderate weight as it's notes that it's afforded a limited weight in.
So just to be very clear, what are you asking the inspector to accord to it?
I'm according significant weight,
Right.
which is the confusion there. But what I'm saying is that is on the basis of it coming forward. I think there's a degree of uncertainty that it will come forward. There's a possibility that an alternative community use might be next step, given the concerns raised in the committee report, and therefore we might give alternative weight on that basis.
Economics, please.
So in terms of economic development, it's pretty standard. You know, construction jobs. There's obviously support for the town. That is slightly weighed against by the loss of best and worst agricultural land. Not a huge difference, but I think the weight I've recorded is appropriate on the basis.
Cemetery.
So with respect to the cemetery, I think it's interesting to note that when this was promoted as a reserve site, it wasn't included in cemetery land. That is the principal difference between the two sites. The cemetery extension could come forward without being within this red line area. It's just a land deal, and therefore, I think the weight accorded is appropriate on that basis. It could easily come outside of the proposed development. Yes, there is an identified need for it, but I think it needs to be viewed in the context of is it a real benefit to these proposals.
Well, let me ask you a question. Is it a benefit?
It is a benefit, but it is the weight I afford to it is on the basis that it could easily be delivered outside the scheme. It's right next to the cemetery.
You said in giving your answer it's just a land deal. What do you mean?
It's not being. It's going to be a market sale, as I understand it. It's not going to be gifted, and therefore it's not a special benefit of the proposal.
Public open space, please.
In the public open space, it's the realistic, how realistic it is to expect this to be used by the wider population. Yes, it does provide space for residents that would be in the scheme were implemented, but in terms of wider use, are people going to travel across all the way from the town to use that open space? I'd suggest that use would be limited beyond the site, and I think the weight afforded is appropriate on that basis.
The proposed energy efficiencies, please.
Yeah, so interesting on this. And what we're seeing, obviously, is the government is in the process of scrapping gas boilers from 2027 in residential developments. The future home standards, which is coming in March next year, it's basically going to make on-site renewable energy generation mandatory, and the building regulations changes are targeted to achieve a 75 to 80% reduction in carbon emissions compared to current levels. So this 60% reduction, which may rise to an 80% reduction in carbon emissions, it's a positive of the scheme, but it's something that's sort of predicting what's to come, and perhaps when the development comes forward, it would need to comply with those requirements anyway under the new regulations.
Is it the same, or is this still require more than would be required by the new building regs?
I think it's in accordance with those regulations. Intention of those regulations changes is development be zero carbon ready, and clearly this is moving towards that, and that is a benefit coming ahead of it. I think it needs to be viewed in that context.
Active travel, provision of active travel infrastructure. Please.
Yes, it is a benefit. There is a contribution to improve bus services. That's separate to the actual travel. There is improvement to the crossings. I think that is a benefit, largely for those on site. But there is standing that it's not improving the wider pavements, which, as Mr. Slack identified, there was issues in terms of the narrowness of those.
That's why you give it what weight? Page 30. Finally, BNG point, please.
As we've seen in other recent appeal decisions in this district, B&G was achieving it. That is a benefit of the scheme. It must be set in the context of the mandatory requirement. It is slightly over in terms of linear habitat and marginally over in terms of overall. B&G is the 10%, but as you see in other appeals, it is only reason to report that.
You say other appeals, I don't think there are any in your brief. Are there any core docs or Fs you just want to sign, please?
Yes, sorry. The appeals Q21, it does apply significant weight, but that is with substantial over provision, 30% plus. And then in terms of the most recent decision, which is Q23, that's a policy provision. Sorry, that's a 10% provision. That's a small weight. So that's.
I got to Q23, yeah.
So Q23 is basically 10%.
Yeah.
And therefore it's small.
Small weight,
In
okay.
that scale of effective weight.
Yeah.
Before we move on to what you say, the downsides and the harms, is there anything else you wanted to add or say on the benefits? Okay then. Detriments then. High wage impact. First of all, what weight are you giving it and why?
So we've obviously discussed the pointers to the refusal reasoning on the basis of the impact being severe. Now, severe wants refusal in itself in accordance with the MPPF, as we've discussed at length. However, in the event that just substantial impact were to occur, I think that is appropriate to still apply substantial weight. It has a much wider impact beyond the site due to the delays. For thousands of people, thousands of journeys, the results in them being stuck in traffic will have a knock-on impact. And you lose a working day and a year stuck in traffic this hours. I think it is appropriate to still afford a substantial weight.
The landscape and visual, please. Obviously, the experts are broadly in line with each other, and the outcome of it. Why? What weight are you awarding and why?
It is obviously going to be hard. It is a contained site that feels part of the countryside. It's not receiving characteristics that allow it to easily be accommodated in residential. It has a separation from the main town. It is beyond the settlement boundary. It's only connected by virtue of the highway element being within the red line. The harm is clearly apparent. There's not a huge difference in terms of the two expert witnesses, but I think the important point that Mr. Cowlin makes in his review, D27, and also in his proof, is that it's the northern part of the site, i.e. the quantity of development, which results in the northern part of the site being identical to housing, that causes the harm. And were that element not to be developed, I think that harm would reduce. But because of the impact overall in terms of the site, the development put forward, I thought that significant.
You've then got a point in planning harms about tree removal to facilitate access. We've not had evidence, so what's your view on this in advice to the inspector?
Yeah, it's not a refusal reason, but there is a harm there. It's 170 metres of tree belt being removed, 16 trees, including 6 mature oak trees. These trees are over 100 years old. They were there from at least 1889 when the branch line was put through. There's a visual, historic, environmental benefit in the screening they provide and the amenity they provide. And those trees will be lost and felt. And that has an immediate harm associated with it. And okay, there's a lot of trees put forward, but as part of the proposals, but those are going to take a very long time to reach the maturity of those trees being lost, and they're not like replacements in terms of the location. They're spread across the site. They're not providing that immunity screening benefit. And it's a point that was raised in the consultation response from the tree officer, CDD7, which he noted there would be significant agricultural harm in the short term. So I think on that basis it is appropriate to apply moderate rate to the harm.
You might well, of course, be asked if you're double counting with the landscape and visual impact when we're talking about removal of trees, if you are asked for your response.
I mean, it is factored in the broader distance views and the role these trees have in that, but of themselves, I think these trees are important in terms of the localised immunity and the fact that they are being lost is pertinent in itself.
Heritage, please.
So, in terms of heritage, I split this up into 2 elements in terms of the non-designated heritage asset, the cemetery, and the designated heritage asset, the Headley Barn, is the building. Now, it's accepted between the parties that there is clearly harm from the loss of the agricultural setting to Headley Barn, grade 2 listed building to the south of the site. The appellant considers that there isn't harm to the cemetery as a non-designated heritage asset, but I think there is. I mean, in terms of the tranquil setting, you experience, as you've seen, so when you visited the site, you can see through those trees. It has a connection to that tranquil landscape, which is important to its significance, and that would be lost. Now, the landscaping scheme as a buffer to that southern element where that harm would be most felt, it tries to sort of, it's a blunt instrument really, it tries to sort of enclose the site. It's not how that setting of that heritage asset is appreciated. It's the connection to the countryside, and simply screening it off and the housing that would be next to it, I think that's it's not sufficient mitigation. So I afford limited harm to that. In terms of looking at impact to the north from the development, to the non-designated heritage asset, impact to the south from the development in terms of the listed building, I treat those separately as 2 amounts of limited harm. It might be appropriate to consider heritage impact as a whole. I think it wouldn't be unreasonable therefore to assume that my understanding, as I present it as basically overall model, because they are from the perspective of the assessment of heritage impact. Why do I avoid limited harm? Reference obviously to great harm in the appendix, but I see that as a assessment purely in terms of the acceptability of the heritage impact on the significance of heritage assets. It of itself, I consider that the impact on the heritage assets specifically, both in terms of the southern part, I consider that acceptable because the public benefits outweighing that heritage harm, but it is still appropriate to lay it in the plan and balance.
And as far as the heritage harm is concerned, you've only drawn my attention to Headlands Farm. There are some other listed buildings south Arthur, I think, all farmers listed. Are you satisfied that those, the extent of the impact on those is limited?
Yes, primarily the impact is the Headland Farm. There is some degree of impact on those I don't consider.
Just picking up some of the points in your, I mean, you started off by weighing them separately.
Yeah.
Why did you weigh them separately initially, and where's this idea of come?
Yeah, so I weighed them separately really to simplicity to match how Headland approached the Headland Barn and cemeteries separate. That's why I approached it in that way. But I do think it is correct to consider impact because the impacts are separate. The impacts to the north of the site and impact to the south.
Last point then, BMB, please. BMB, best most versatile
BMB,
like agricultural.
yes. It is best and most versatile agricultural land. There is a harm associated with the loss of best and most versatile agricultural land, 91% of it. In terms of that, it is accepted that there's an inevitability of developing a large rural location.
Thank you. And then just stepping back, your advice, please, because it's very easy to get lost in weights and measures and whatnot in planning, but this is a human question at the end of the day. So your advice to the inspector, stepping back on why the balance comes out in the way you say it does.
So it isn't the council's case that residential development cannot be the site. It is that this scheme is too much. It is the 275 homes and the extent of development that results from this that is causing the predominant heritage visual impact that is impacting on the cemetery, that is resulting in the quantum of transport movement by car that is causing harm. We started from a refused application for 40 units, and it's dropped to 275. I don't consider that sufficient to overcome those harms, and neither do my colleagues in terms of the proofs and heritage and from transport and landscape. They obviously identified sufficient harm to justify refusal on the. Was I clear enough there?
Okay, thank you, Mr. Grant. Ms. Shalaby, I'm just thinking, rather than split cross-examination across two parts, it might be a good idea for us to have an early lunch and then for you to do cross-examination all in one block. Would you be happy with that? I prefer it because otherwise the you know it comes a little bit disjointed, doesn't it? So I know we're quite early, but I think it's probably right to break for lunch now, and then we'll return to hear cross-examination of Mr. Moss. So where are we? 12:15. Let's adjourn until 1:15, please. See you back here at 1:15. Good afternoon, everybody. 1:15, and the inquiry is resumed. So we heard evidence in chief from Mr. Moss this morning, and now it's the opportunity for the appellant to cross-examine him on that evidence. Michelle, over to you.
Mr. Moss, we're going to start with a bit of background in terms of the council's historic treatment of the appeals site. We know, of course, the site is on the edge of Malden. And Malden is a core focus for growth in the existing and, as far as what we know, in the emerging local plan strategies. And we agreed, as Mr. Slack confirmed last week, that the site itself is in one of the most sustainable locations in the whole district.
Yes, in the context of continuing with this, issues with sustainability by non-crime members.
And of course, we know, as you discussed in your examination in chief, that the council put forward the site as a reserve allocation with an indicative capacity of 450 when it was preparing the current plan. Yeah. And you spoke a bit about what happened, just so the inspector has the right story. So during the examination, the inspector for the for the current plan queried whether there was sufficient evidence of infrastructure capacity on education and highways from Essex County Council. That's right, that's what happened. And in response to that, the council changed tack, and instead of reserved sites, it put forward a main mod. Do you recall that?
Yeah. Main ones.
Yeah, and instead it committed to a partial review of the plan if the allocations delivered less than 75% in 3 consecutive years. And that's what's currently in the plan. And we'll return to this later, but that review was triggered almost immediately after the first 3 years in 2021. Well, we're going to come back to the local plan review. It's a matter of fact the council said in 2021. You'll be taken there again in the examination if that's wrong, but we'll come back to the review in a bit. And of course, in this appeal, Essex County Council have confirmed that with the agreed mitigation, there is sufficient education and highways capacity for this scheme to come forward.
That is the view of the county highway department. So the measures in terms of contributions.
Yeah. And so after the council had consulted on the main modification to delete the reserve sites, it's then that it did the sustainability appraisal that we've got at J22. So can we just pick that up briefly? CD J22. And I think we're going to page 273. There's no suggestion from the council, just to be clear, because I wasn't clear from your evidence, that it deleted the site on the basis of J22, because it was gone out for the main mods before it even did J22.
Site was removed before having had no prior sustainability appraisal effective to identify these results.
And so the first point on this, so with RE49 Malden Hall Farm site, nothing in there to suggest that there would be unacceptable landscape impacts.
Take me to
So table S49, page 273 of J22. Sorry, it's PDF 273, internal 269. Yeah, so nothing in that to suggest the council thought there were any unacceptable landscape impacts from this site. We've got 14, local character could be affected, but there's nothing there to, you know, in the same way.
Could be effective. There's a minus.
Yeah, but nothing to say that that's a unacceptable, you know, a really big problem.
It's identified as an issue,
Yeah.
but this document will determine the acceptability of communication of the issues related to
And in terms of sustainability, we can see there's a few boxes that you pointed to, so 11 and 12, I think, saying that there may be an increase in dependency of the private car. And then what it says at the end there for both of those is the impact could be dependent on whether or not there'd be access provision across the A414. And of course, here we are proposing pedestrian access via the Toucan crossings over the A414.
It could be dependent. That's
And of course, this sustainability appraisal doesn't take account of any of the specific infrastructure improvements this scheme is putting forward. So the crossings, the pavement extensions, the signs, the bus stops, the bus upgrades, none of that's taken into account here.
not in this appraisal. It doesn't take into account potential works to mitigate harm from capacity improvement.
And while the reserve sites were not ultimately included because of the council's change of strategy, the inspector who examined the plan in his report did conclude they were both developable and deliverable for housing.
The inspector determined it appropriate to take those out for consideration through that process.
We've just discussed the process. The question is, while ultimately they weren't included, the inspector specifically concluded in his report that the reserve sites were both developable and deliverable. So,
Take me to that vote.
yeah, so it's J16 is the inspector's report. And it's paragraph 217 on page PDF 37. And you see there the reserve sites included were intended as a contingency in the event of housing under delivery. While I consider the sites to be deliverable and or developable, there's not a cast iron guarantee they can or will be developed at the point envisaged, and prudence should be exercised. So he concluded there that they were, in his view, deliverable and or developable.
Yes, and he also advised in context of the scale of the infrastructure requirements, prudence should be
So that's the existing plan. I just want to jump forward then to the council's evidence base, what it is for the emerging plan. So while there hasn't been a great deal of progress on the plan itself, what we do have is the HELA exercise carried out in 22 to 23. And of course, in the HELA, the council concluded again that the appeal site was suitable, available and achievable for housing development.
then be taken to the healing document.
Yes, I mean, so that reference is from the Statement of Common Ground CDS1 at 3.24. The 2023 HELA is CDK3, and we're on page 49, but I think the most useful place to go is where the detail of the assessment is, which is CDK1. And that's the spreadsheet where the council does the assessment. And we are in row 102. So right at the bottom, site Malden HY15.
Yeah.
So, of course, as you pointed out, this is for a site that is far bigger than the appeal site. So I know you said in chief that 275 homes was, in your view, too much, and that was the real problem here. But here in the HELA, the council's considering some 1,000 homes over an even bigger site as suitable.
They
Right.
are, and
Yeah.
the context of that is the site is a wider site. There is the ability to accommodate a mix of uses and transport improvements to help make water sustainable.
Let's see what exactly is actually said about all of those things. So, I mean, if we look at paragraph H, column H, sorry, and this is talking about accessibility to services and facilities. And this looks like it's talking about the current status of the site itself. And what it says is the site is within walking distance of services and facilities of the town and these could be accessed safely by walking. Therefore, the site could maintain and improve accessibility. So the council there thinks the site is within walking distance.
Sorry, can you just give me that paragraph?
So it's column H in row 102 of CDK1. You see that?
Yes, yes, they do.
Well, they actually say the site is within walking distance, so they seem to think it's currently accessible.
They do, and they say therefore the site could contain.
Yeah. So the council there thought it was effectively in a sustainable location.
It said it was within walking distance of services of the town. Therefore, a wide range of services are. Let's go over Mr. Sats.
And then in terms of landscape, if you go to column L, again, this is talking about the current status of the site, and this is actually for an even bigger site. The site is enclosed in terms of its boundary treatment and would not impact on the wider landscape. The site does fit in with the context of the townscape because it's to the east of the site. So again, that's the council's own position on an even bigger site just a few years ago.
In the relative terms of 1800.
Yeah. And then finally, if we just go to the conclusion at column X, on balance, it's considered the development of the site would be suitable. It's located adjacent to the existing, I assume a word is missing and should say settlement there. A safe pavement can be created to the services and facilities of the town, and these can be accessed by walking. Heritage impact assessment would be required. The site's relatively enclosed, there would be minimal impacts on the wider landscape, and the site's adjacent to the existing settlement, so fits in with the townscape. And no material factors on the ground have changed since that assessment that the council itself did in 2022.
Yeah, I think it is material to note that safe pavement access can be created.
Yeah.
Proposals don't propose pavement improvements to address these issues identified.
Well, they do. It does propose pavement improvement in the locations that have been identified by Essex and our highways experts. And Mr. Sack confirmed it is no part of his case that safety is any issue whatsoever. So that's not helpful, is it?
It is helpful insofar as beyond those works there are issues with pavement.
But this is talking about pavement access from the site. There's no suggestion that a scheme on this site should be altering the pavements in Malden town centre. That would be entirely unreasonable to request.
No, but it is saying a safe pavement access can be created for the services and facilities which might include the vehicle import.
And pavement access is exactly what's proposed. So that's an assessment the council itself did, taking all the considerations of this appeal into account, concluding an even bigger site was suitable, achievable and available for new homes. You said in your examination in chief that it should only get limited weight, this exercise. But in terms of the appeal decisions, I wasn't sure which ones you were relying on, but there is a very recent appeal decision of Inspector Parsons, CDQ 23. I don't know if you've got that, but at paragraph 45, the inspector confirms there the healer should attract moderate weight. For 45 CDQ 23. So that's a similar case where, despite the negative view, the council itself concluded in the healer that the site was sustainable, and as an evidence base for the emerging plan, this would attract a moderate level of weight. So, are you happy to accept the decision of that inspector on that
In
point?
respect of that site, that's clearly certainly.
That's about the status
and
of the
I'm
healer.
not sure if that assessment assessed that specific site has matched the red line area.
So what the inspector's saying there, as an evidence base for an emerging plan, the healer would attract a moderate level of weight. Do you accept that? I don't think we need to go there, but there was also in the Latchington decision, we've got CDQ 21. the inspector there didn't give a weighting, but said there was no reason to depart from the findings of the healer. Because, I mean, it is the council's own evidence, and the council's sufficiently confident in it that it's put it in the public domain.
It's not subject to exclusive legal examination, but yes, it is in the public.
And it's the latest version. It hasn't been superseded by anything yet. Right, so together all of that indicates the council's previously accepted the appeal site as suitable for residential development of an even bigger order than proposed here.
They considered a wider site as having the potential to accommodate residential development.
And with changes to the standard method in 2024, the need for Malden, since all of this has been carried out, has almost doubled. So going forward, there's going to be significantly more pressure to find even more sites that are suitable than there was at the time of the 2022 healer.
Heller does identify
And then moving forward then, we're still on the council's previous stance on this site. So I just want to fast forward to the present application. So this is a scheme that was designed with input from the council over more than a 2-year period, starting in 2022. There were 7 pre-app meetings and a site walkover. Obviously not controversial, reported to committee with an officer recommendation for approval. No objections from statutory consultees. And of course, members took a different view, recommended refusal on a number of grounds. And in terms of the planning reason, one reason for refusal, one in relation to infrastructure, you decided that that wasn't defensible.
I did, yes.
And in terms of the highways reason for refusal, you also heard Mr. Slack confirm that 3 of the 4 locations listed in that weren't defensible as well.
In terms of the junction, didn't have the evidence.
Yeah. And of course, even at appeal stage, your client still accepts that the residential development proposed is in principle acceptable on the site, and we've got that in the statement of common ground. Well, it says the residential development in the statement of common ground.
A residential.
The council.
We're talking, you know, 270 quantum.
Well, except it's very clear in the statement of common ground that it says the residential development. It's not a residential development. So even in the process of this appeal, your clients accepted that this residential development is in principle acceptable.
The principle of residential is acceptable, but subject to the
Well, it's quite difficult, isn't it? Because this is an outline application. The principle of development is accepted. You see, it's a pretty difficult starting point for the council to be reasonably suggesting that the outline application should be refused when the principle is acceptable.
we're talking about the relevant quantum. Earlier, we had the 340 dwelling scheme, which is we now have a 275 dwelling scheme. The position is the harms would be much reduced, so it becomes potentially development, there is this quantum development. We're only in the 275 dwelling scheme.
Well, that's not any part of your written evidence, and the statement of common ground does not qualify the principle in that way at all. It doesn't say a smaller number of homes would be acceptable on the site. It says the principle of the residential development is acceptable.
Yeah, I mean, we can get through all these.
Yeah. But it's not really a good starting point. I'm going to move on to the development management framework and the policies. So first, can you take up the MPPF? It's a core document at CDI1. Might have it separately. And so when you're there, the first place I want to go to paragraph 7, which is under the heading Achieving Sustainable Development. And we see there the purpose of the planning system is to contribute to the achievement of sustainable development, including the provision of homes. And I mean, that's an insertion into recent versions of the MPPF. It wasn't there in the first one, was it? And it reflects the fact that providing homes is right at the heart of the MPPF. It's the very first thing they say there at the beginning of this section.
Provision of homes for actually development supporting infrastructure.
Yeah.
One of
Yes. Again, I think if you say yes or no and then qualify, so yes. And then 8B, we've got the overarching objectives and the social objective in particular, which talks about ensuring sufficient number and range of homes. You see that there? And then if we go on to section 5, which is page 17, the theme is picked up again. So we've got a whole section delivering a sufficient supply of homes. And the familiar paragraph 61, which is to support the government's objection of significantly boosting the supply of homes. You see that there?
yes.
And that's an important objective that permeates the MPPF, isn't it? And one of the mechanisms to achieve that objective is on page 21, so achieving supply and delivery, maintaining supply and delivery. And we see in particular at paragraph 78, the second sentence there, local planning authorities should identify and update annually a supply of specific deliverable sites sufficient to provide a minimum of 5 years worth of housing. And that of course, that sets out a minimum. It's not a cap on delivery. It's the bare minimum all authorities have to do their bit to support the objectives we've just talked about. So next then, while we're in the MPPF, I just want to go back to the presumption in terms of sustainable development. So sorry, jumping around a bit, but back up to paragraph 11. I think this is all agreed between us, but just so the inspector's entirely clear, and I'm entirely clear. So we're in decision making at paragraph 11, so paragraph C and D. Paragraph 11C says approve development that accords with an up-to-date plan. We're not in paragraph C because there's no up-to-date plan. So we agree we're in 11D, and that's because the most important policies for determining the application we agree to be out of date. Because Malden's not meeting its local housing need number. And of course, the standard method housing numbers reflect one of the government's most important policy priorities, which is to arrest the housing crisis. And in fact, we've got the Secretary of State in various documents here describing it as acute and the worst crisis in a generation. Yeah, it's in, I think, Mr. Pycroft and Mr. Roberts, but one place is CDI 9. We've got one of the recent written ministerial statements. So the government's inherited an acute and entrenched housing crisis. Number of children in temporary accommodation stands at a historic high, and so on. You see that there. The first paragraph.
Yes.
Yeah. And so the changes to the standard method are a deliberate intention to encourage councils to do a better job at meeting real needs than they have been for recent decades.
Yeah, we're encouraged to deliver the 5-year housing. Bring forward sufficient sites to address this housing crisis.
Yeah. And so on 11D then, we agree the most important policies are out of date. Is it your position that they're out of date on account of the 5-year housing land supply only, or do you think there are also other reasons they're out of date?
I consider them to be out of
Okay, so we'll get on to some of the other reasons they might be out of date in due course. But in any event, what that means is that essentially what the inspector has to do is grant permission unless either D1 or D2 stops him from doing that. And D1, we agree there's no strong reason for refusal. Applying the footnote 7 policies. Yeah. So we're in D2, the tilted balance, and the inspector has to grant permission unless any adverse impacts would significantly and demonstrably outweigh the benefits. And that's the DM test under national policy. This is also a case where the DM test is the very same under local policy, isn't it? If we take up the local plan then, CDJ1, and I think you know where I'm going, but it's policy S1 on PDF page 14. PDF 14, sorry, I don't know if you're working. Oh, it's the same. Luckily, it's all the same in the plan. Very helpful. So we see the start of S1 when considering development proposals, the council will take a positive approach that reflects the presumption in favour of sustainable development contained in the NPF. So that's what we've just discussed.
Yes. With the application.
Yeah, but the point is that the tilted balance in the NPPF feeds through into the local plan, doesn't it?
Yes.
So essentially, the development management tests are the same under the local plan and the NPPF. It's the tilted balance in both cases.
Yes, I accept those pieces.
And while we're in S1, I just want to take a look at the structure of that, because you referred there to the second half of the introductory paragraph, and it says it will apply the following key principles in policy and decision making. So, I mean, it's not a policy that says refuse schemes where specific criteria are not met. It's sort of setting out a wide range of considerations that will be applied in general in decision making.
Yes, it's not about vast policy.
And it's not any part of the council's case, anywhere in your evidence or anywhere else, that there's a conflict with that policy in terms of any of the landscape impacts. Not in the reason for refusal or your evidence at all. For that reason, I assume, because it's more sort of general principles approach.
Yes, because it's a positively worded policy.
And I think the only conflict you do identify with that policy in your proof was in relation to the evidence on sustainability. Now it's been agreed with Mr. Slack that the test at 110 of the MPPF is met, and the site's one of the most sustainable locations in the district. Is it fair to say the council accepts S1 is complied with too in that regard?
Yeah, I would like to clarify that. I think the position is that it can be made sustainable.
Yeah.
And our view is that it hasn't been made sufficiently sustainable. Which is why the transport impact.
But of course, the council hasn't requested any additional sustainability improvements, has it? No. And the only point the council did make about the sustainability measures related to the bus stop, and that's now gone. The bus provision, that's gone away.
Yeah, indeed, of the measures that are proposed, that has been addressed.
Yeah.
I think the question mark is still that whether that will facilitate switch of roads away from the car.
But the point is the council accepts it can be made sustainable. That's the test in the MPPF.
It can be made sustainable.
It doesn't propose any additional sustainability measures that the appellant should have done.
There are no required.
Nora appeal. And in respect of all these policies, it's right that the inspector has to consider the policy as a whole. Conflict with one part of it might not mean conflict with the whole policy. In the same way, conflict with one policy might not mean conflict with the whole plan.
That has to be done.
And in considering the plan, of course, as you've done, the inspector will need to consider the weight that should be attached to any policy conflicts he identifies. And that requires, of course, considering whether they're out of date, and whether they're consistent with the MPPF. And so just going to start with the question of the out-of-dateness of the plan in general. So it's adopted in 2017, so almost a decade ago now.
Yes.
And it was examined, we know, under the original 2012 NPPF. There's been 6 revisions to the framework since, including significant changes to the approach to calculating the housing requirement. And in fact, I mean, the key line in the sand for the housing requirement was the 2018 NPPF, because that's when it changed from local authorities coming up with their requirements via objectively assessed need to a sort of government mandated standard national method.
To a degree, I think the December 2024 changes are pertinent.
Yeah, very pertinent as well. But I mean, this is before 2024. It's before 2018. It's 2012.
Change, yeah.
Yeah. The plan period, it was adopted in 2017, but the plan period actually starts in 2014, doesn't it? And much of the evidence base, obviously, is even older than that.
Some of that.
And if you go back to section 1 of the plan, if you could go to paragraph 1.23 on page 6. It's PDF page 6 and internal page 6 on mine, but maybe they
Okay.
don't align. So we can see the plan making process actually started there in figure 2 as far back as 2007. So there was issues and options, preferred consultation in 2009, then another preferred options document consulted on in 2012. So, I mean, all in all, it ended up taking 10 years to adopt this plan. And of course, the spatial strategy of the plan is to focus growth in the most sustainable locations within a rural district, as you've said, and that includes the town of Malden. Yeah, so it's at the top of the settlement hierarchy, isn't it? And so in that respect, by directing development to the edge of the Tier 1 settlement, the scheme broadly complies with the spatial strategy of the plan.
It is outside the settlement boundaries, and the spatial strategy is to focus development within to the allocations and existing areas. This is outside the settlement.
In terms of the broad approach, by directing development to the edge of Malden, that broadly accords with the general spatial strategy. I understand the point about the settlement boundary, but broadly that's what the plan's trying to do.
I'm not sure to confer that, but I guess it's we've identified previously that Malden is a more sustainable location.
So does it broadly accord with the spatial strategy of the plan?
Say there's broad accordance, caveat that obviously it's outside the settlement boundaries, but it's not within the Tier 1 settlement.
And I mean, we've got a recent appeal decision. The inspector at the Broad Street Green Road, which is CDQ 22. Paragraph 139 of that. The Haybridge one. So similar situation.
Sorry, could you just give me that
Sorry,
reference again?
Q22. A paragraph 139. And we've got so same there. The appeal proposals adjoin one of the most sustainable settlements where strategic growth is promoted, and so it reflects the overall spatial strategy, even though it's outside the settlement boundary.
Bill, yes.
Yeah, so same applies here. You accept that?
Well, this site doesn't, apart from the highway element, but where the developable element is, where the housing is going to be built, that is separate from the settlement boundary. That's the nuance.
Well, you've got allocations that go beyond the A roads. I mean,
Well, those
Be-
are allocations.
be fair, Mr. Moss. I mean, the same approach applies. It is just on the edge of the main settlement, and for that reason, it accords with the general spatial strategy of the plan, notwithstanding your point about the settlement boundary we'll come on to.
Yes, I accept that point with the caveat that it is severed in the way this site is not.
So back to the plan then. So the strategy of the plan was, of course, employed to deliver a particular housing number at a particular time more than a decade ago.
Yeah.
And we've got in S2 the requirement of 310 homes, DPA. So, I mean, that's what is. So that's what's agreed in the 5-year housing land supply statement of common ground. I think that's what happens when you do the calculations within S2. But I think it's common ground in the 5-year housing land supply statement that the current requirement when you work it out is 310.
That's not an S2.
Oh, it is. It's the second paragraph of S2.
Oh, yes, I see it now. Apologies.
So that's set against a current requirement of, we heard this morning, either 584 or 586 and 613 with the 5% buffer. So essentially, the development plan is based on a housing target that represents half of Malden's true housing needs. And even at the time, as Mr. Wheeler points out in his evidence, the housing figure was based on data, some of which went back to 2001 to the census then.
As I understand it.
So the adopted housing requirement is in part based on census data that's now partially 25 years old. And it has the housing number at the core of the council's spatial strategy. It has no relationship to local housing need. It's not a policy based on any up-to-date assessment of Malden's actual housing needs today. And in that way, it's fair to say that S2 is fundamentally inconsistent with the approach now required by the 2024 NPPF.
It's still relevant that the policy promotes sustainable development, focusing on main settlements.
Sure, but in terms of the number and the strategy, sorry, I thought you'd finished.
To constitute the most suitable and accessible locations in the district.
In terms of the numbers and the strategy for achieving those, it's not consistent with the MPPF, is it? Because it doesn't reflect in any way an up-to-date assessment of Malden's current local housing needs.
Yes, but I would clarify that there is provision in this policy for development proposals in excess of the allocations needing to demonstrate the satisfaction of council that they won't produce the garden centres, which they don't, and that there'll be sufficient infrastructure to support them, which will include highway capacity.
Yeah. And as you say, all infrastructure matters, other than Mr. Slack's point on highways, that's all agreed with the council in this case.
Insofar as the contributions to education, etc., including nursing places. Yes, that's all.
All agreed. And because S2, as we've agreed, is inconsistent with the current NPPF approach in terms of housing numbers and the strategy it deploys to achieve those, that has to reduce the weight that applies to it, doesn't it?
Yes, it's out of date. The weight reduces so far as it seems to be development to those settlement boundaries. Yeah, it's at that point, but it still addresses the development in excess of allocations. I think that's still pertinent. It refers to these requirements. Notably, that there will be sufficient infrastructure needed to support development, which we've agreed includes highways.
So in addition to the point about the housing numbers and the strategy, there's the question about what S2 requires in terms of landscape. So at the start it says the council will promote sustainable development whilst contributing to protecting and enhancing the district's natural, built and historic environment. So I don't read that as a requirement for every single development to enhance the landscape. It's a broad objective in terms of strategic growth as a whole, and I think you agreed with that.
I read the policy that way.
Yeah. So a development can comply with that policy even if there's some landscape harm.
Well, it might not achieve what's sought by that element, but overall it can the policy can allow for some harm on specific sites as part of the overall.
And I think, as you fairly said for heritage, if it didn't say that, if it said every development has to enhance the landscape, that would be inconsistent with the NPPF, wouldn't it? Yeah. And so if there's going to be strategic growth, there is of course going to be some landscape harm in the district, and it's about putting it in the most sensible places and protecting the most valuable landscapes. And so given this is not a valued landscape and it's on the edge of a settlement, fair to say it broadly complies with that overarching objective as well.
I think in the evidence of roundtable session, it's brief. He said his view was that there is harm. It might not be a valid landscape in the actual definition. There isn't no designation of landscape areas, landscape areas, and it is relevant that that harm occurs.
Okay, well, first of all, if you answer with a yes or a no
Yes.
again, but so if we go back, we've just agreed that you can comply with this policy, notwithstanding having some landscape harm.
Yes.
We agreed that the overall aim is to protect and enhance the district's natural environment, and if there's going to be strategic growth, there will be some impact. We agreed it's about putting it in the places that protect the most valuable landscapes. We agreed this site is not a valued landscape, but there are other valued landscapes in the district, as Mr. Cowlin pointed out. He referred to some even in Danbury and the Chelmer Valley. Do you recall
Yes,
that?
and equally there are areas which don't have.
So it's fair to say that the scheme broadly accords with the intention of the policy, which is to protect the most valued landscapes in the district.
I mean, yes, but I'm saying that is nuance. It's hard for me to judge on the relevant impacts to schemes that aren't. There will be other schemes out there which can landscape best today. So I would say it's not. It doesn't mean that it's contrary to that requirement because the overarching approach.
Okay, thank you. I think that's it for S2. Just some questions briefly about policy S8. So it's agreed between us there's a technical conflict between S8 because we're outside the settlement boundary. Yeah. And I think it's also agreed between us that the settlement boundary policies are out of date because of the housing position.
Yes, albeit there, as I've mentioned a few times, the provisions in respect of development outside of the settlement boundaries are still relevant as I see them.
And I mean, it's more than just the 5-year housing land supply that renders S8 out of date, isn't it? I mean, the settlement boundary around Malden, that hasn't been updated in a decade since the adoption of this plan.
The plan to change that designation or any other settlement boundary.
There's no strategic review of the boundaries or anything like that, has there? And that's notwithstanding the housing requirement having doubled. So,
Well, yes, they haven't delivered a new local plans.
so it's fair to say, I mean, the settlement boundaries are substantively out of date at this point.
They are out of date for the purposes of.
But not just technically, they're substantively out of date because the numbers are so far out of whack with the current MPPF.
Out of date equally for the
Yes. Substantively as well as technically.
Yes.
So, and of course, that's why, isn't it, that there is no reason for refusal in this case on the basis of location outside the settlement boundary. Because it's accepted that the council will need windfall sites outside settlement boundaries to meet its housing needs. And they're going to have to be, some of them, greenfield sites as well. I mean, there's no other way of meeting the current housing requirement, is there? There's no huge amount of brownfield land that's just waiting there ready to go. We're going to need greenfield windfall. So we agree windfall greenfield sites are required. So it's not a question of if greenfield sites are required, it's where they should go. That's what we've got to think about. And I mean, the real objective then should be to try to find sites that are not in the most valued landscapes.
Yes.
With no major flood risk. With no overarching heritage or ecology constraints. And with proportionally good sustainability in the context of the district as a whole. So the other point I think you wanted to make about S8 is it has some requirements or provisions in relation to schemes where you are outside the settlement boundary. And what it says is planning, so this is after the
I think my point was more in respect to S2.
Right. So, but because I think what S8 says is, it does say permission will only be granted where the intrinsic character and beauty of the countryside is not impacted. But we agreed a few minutes ago, if that's meant to be saying no detriment whatsoever, that would be inconsistent with the current NPPF.
Yes, but obviously you have to have regard to the impact of the landscape and the relative harm associated.
So S8 is sort of, it's out of date in two ways. So first, the settlement boundaries, but also the threshold for landscape impacts inconsistent with the NPPF. Because it apparently requires a nil detriment, and we've agreed that's not current
I don't
policy.
think it's saying that. I don't read it as saying that.
Where it says development will only be granted if the character and beauty of the countryside is not adversely impacted. After the table.
I'm not reliant on that.
Okay, so
I'm reliant on the general provision the countryside will be protected with its landscape, resources, ecological value, as well as change of character and beauty.
so the council's not suggesting any conflict with the second part of that policy.
I think because of the nature of the rate to be afforded to things like rural diversification and essential farm workers, that's sort of the way to do it.
So in terms of other policies the council's relying on, I'm not entirely clear about D1 because Mr. Cowlin said in his evidence that the council wasn't making a case about policy D1, but then I thought you said in chief that the council is now making it. I mean, Does the council accept that's a design policy and it's more relevant at reserved matters stage?
No, I think the point being is, all development must, it's a requirement policy, all development must respect and enhance the character and the context and make a positive contribution. Now, at outline stage, we've identified that by building close to heritage assets, non-designated, and the designated, that's relevant. So we're focusing in on the landscape here.
Yeah.
The impact on the landscape setting, it is still pertinent.
The council doesn't suggest conflict with that on heritage. So we're looking at landscape. And the point I've just made, which is that a policy that requires a positive contribution and no harm is totally inconsistent with the approach of the NPPF. That applies again to D1, doesn't it? Because it says it's got to make a positive contribution in terms of, for example, at C, landscape setting. I mean, the NPPF does not require you to positively enhance landscape setting. It's not possible for green.
That second part, positive contribution, I do agree with you, that does not negate the need to respect.
That, of course, reduces the weight because there's some inconsistency with the NPPF. It has to.
That element of seeking positive contribution, accordingly, albeit you are required to include the development plan. But that's the starting point.
So that's the adopted plan. I now want to move on to the attempts to replace the plan. So, as we've discussed already, the current housing requirement's much bigger than what the old plan was looking at. And Malden is a town that is subject to some quite significant constraints which materially limit its capacity to accommodate growth in other areas.
It's challenging
Because of that, but also in terms of the town itself, we've got, could you take up Mr. Wheeler's proof, CDE3? If you could go to figure 3 once you get there. Yeah, let me just try and find it myself. PDF page 30 or internal page 29. So, I mean, everything other than to the west where we are has a flood risk problem, essentially, and that's limited the council from allocating sites in previous plans and in the Healer and other documents.
There is an element to the southeast and to the southwest.
But essentially, you've got to be to the west.
To the southeast and southwest.
The tiny area beyond the existing built development to the southeast. But the vast majority of development is going to have to go. It's going to have to go west. You can see that there. And in terms of the areas to the west, I mean, we heard Mr. Cowlin saying the area north of the site towards the Chelmer Valley, that was more valuable, potentially a valued landscape. So that's probably not suitable either.
On landscape terms, yes, that's more sensitive.
So, I mean, if you're going to have to double the numbers in the current plan, and the current emerging strategy, as we know, is still to focus growth on Malden, yeah, it's inevitable the council's going to have to include the appeals site as a proposed allocation in the emerging plan. There's just nowhere else it could go.
There are a number of options for a development strategy that hasn't been formed yet. There are other tier 1 settlements, the Heller, various other sites in other areas. Malden has taken a lot of development. There is infrastructure issues. I know that's not part of our appeal, but there is certain transport issues. I think we're prejudicing the outcome potentially of the local plan. That's a process that will be followed.
Well, we've agreed that the growth work the council has done for the emerging plan, and this is in the statement of common ground at 7.19, and we've got the documents in the core documents as well. All of that identifies a focus for future growth on Malden. That's the strategy going forwards.
That's one of the bonus.
Yeah.
I mean, that's sort of one of the towns. That's the main stage.
It is, but everything we've seen focuses growth on Malden, and just I appreciate this isn't the emerging plan, and this is just just a sort of realistic consideration, looking at that plan and knowing we need a lot more growth and a lot of it's going to be directed to Malden. It's going to have to be where the appeal site is. There's really limited other options.
If you're saying that development has to, yes, if you're saying that development has to go to Malden, there is land to the southeast, there's land to the southwest, extending the existing suburbs. There is also land to the west. There are, as I said, other settlements. There is scope to expand there. We have railway stations here. I think you're sort of jumping the gun to say that means that we're going to get, this is the only option for Malden with the district.
Well, so what we've
I appreciate your line of questioning,
Yeah.
and I think you pushed it about as far as we can go on this one. Obviously, I'm determining this
Yes.
appeal rather than this
Of course.
struggling, you know.
Of
So
course. I appreciate
I appreciate we've probably gone as far as we can on that.
Okay, well, we'll leave that there for the inspector to consider. We want to think a bit about the progress that has been made on the local plan, and you said it's at an early stage. What we know, and I told you I'd come back here a bit later, that we've got the trigger in the plan where it had to do a review if it didn't have 75% of projected completions over 3 years. And that trigger was met almost immediately in 2019 and 2020. And the council itself accepted there was a need for a review back in 2021. And it's in, I think that's in the main statement of common ground, CD S1 at 5.6, where it explains work began on a review of the Malden plan in 2021, and the details also set out in Mr. Wheeler's evidence about the review being triggered.
Just over the S1.
5.6.
Yep.
So the review began in 2021 as the plan indicated it should. And at the time, and this is set out, but I don't think it's controversial, in Mr. Roberts' evidence appended to Mr. Wheeler's proof, the council adopted an LDS that anticipated an updated plan would be adopted in autumn 2023.
Paragraph again, please.
Yeah, so that's Mr. Wheeler's proof. So CD E3, Appendix KW4, which is Mr. Roberts' affordable housing evidence, and then it's paragraph 2.14 of that. So if you're in the PDF, it's PDF page 77.
Yes.
Yeah, so the LDS at the time thought an updated plan would be adopted in late autumn 2023. I don't think the council's contested that anywhere. And that 2.5-year window turned out to be extremely optimistic.
Seems so.
I mean, since 2021, the council has had loads of time to progress the local plan, but it's totally failed to do so.
Yes, I mean, I understand that the intention was to have a local plan by summer of this year, and in spring 2024 there was progress on that to a 15-year local plan, and scuppered obviously by the change to the standards. The short answer is they haven't progressed.
Yeah, I mean, there's been extremely limited progress. There's currently no draft plan, no draft strategy. Council's still not proposing the very first step of a Reg 18 consultation until the end of this year. So there is no evidence that this inspector can rely on to say that the council is seeking to address the housing shortfall in any strategic way.
It's slow, yes, it's slow.
And given the total collapse in plan making, there's no real remedy to the housing land supply position in the short or medium term.
Yes, the remedy is plan applications.
So there's no plan-led remedy. The
There's
only
no plan.
the only solution is relying on
Yes,
windfall
there's no
sites.
plan-led remedy.
So I want to just look at the current LDS and what that says. So we've got that at CDJ 13. So it's dated February 2025, so it's more than a year old already.
Yep.
And we see in that table 1 has the timetable. We've got consult on the proposed strategy end of this year.
Keep directly to the page.
Sorry, page 6,
Yep.
timetable.
Yes.
So at the end of this year, Reg 18, and then the plan supposedly adopted essentially 2.5 years later in 2028. Does you understand it? Yeah. I mean, you'll recall last time it took 10 years. This is looking potentially quite optimistic.
Yes, albeit 11D's now in play and to get control over housing. It's an impetus to do that, and also the plans combining the authorities by 2028. See an impetus to progress this.
Well, I mean, there's nothing at all. You make that point. There's nothing in this LDS that makes any allowances whatsoever for the consequences of local government reorganisation. And we know, don't we, that Essex is one of the areas identified for the devolution priority programme. And it's formally progressing, as I understand, towards the establishment of a mayoral combined county authority. Well, it's set out in Mr. Wheeler's proof, and he explains there that the first mayoral election was actually anticipated for 2026, but that's already been deferred to 2028. And the government's currently consulting on competing proposals for how Essex is going to look. So there's significant uncertainty around the future governance of the area. And I mean, we don't even know what council will exist in 2028 to adopt a plan.
Yes, albeit the expectation is there will be a combined mid-Essex council by 2028.
So Malden might not exist by the time this LDS suggests Malden's going to be adopting a plan.
My understanding is there's been private company brought on board to progress matters on the plans. Try and make sure we have a local plan in place before that deadline. It's expected to be transferred to the
So best case scenario, new plan 2028, but I mean, realistically, we have no idea if it's going to be then or considerably later.
We have the programme and we have a private practice working to stick to that programme. So
We don't have any details of the work of the private practice. You haven't put any of that into evidence, so we can't discuss that. But all we've got is this programme, and this programme doesn't take into account anything about local government reorganisation.
other than targeted before that.
And it doesn't take into account any delays engendered by the government bringing in a whole new plan making system since this LDS was adopted.
Yes.
Yeah. So we just have no idea really when a new plan will be adopted.
We have a reasonable idea, but we cannot be certain. I cannot promise you that we'll be able to.
And it would take longer still, obviously, for homes to actually be delivered pursuant to any allocations in any emerging plan.
Yes, albeit there will be increased weight of the plan progresses around schemes to come forward.
And you accept, I think, that it's unacceptable for people in housing need to have to wait until the new plan's adopted. That's not the council's position.
Petition and council can understand it.
Yes, so the council accepts. It has no in principle objection to schemes coming forward in advance of the plan. It doesn't say people should have to wait for the new plan. I'm going to move on then from the numbers and the plan to consider some of the impacts of all of this failure to plan and start with market housing. So we've agreed in the statement of common ground that there's a national housing crisis that's both acute and entrenched. And the consequences of that are social, economic, they're wide-ranging.
Yes or no? That.
And the average home's now beyond the reach of the average worker. Housing costs consume around a third of private renters' incomes. It's a real crisis that the country's in. And we'll go through the figures in a moment, but fair to say that all of that applies, as it does in many districts, to Malden as well.
It's common to Malden.
And so, obviously, that means there's also an acute and entrenched local housing crisis, and that needs to be tackled, you accept?
Yes, through the delivery of housing. And the mix of housing.
And in terms of housing supply, I'm not going to revisit any of the matters we've discussed this morning. Mr. Pycroft's gone, and I don't want to ask any technical questions without him. But on either case, so on your case, the shortfall over the next five years is 626 homes. On Mr. Pycroft's, it's 899 homes, maybe just pushing over 900 with the one or two change to the LHN. So not tens of homes, but hundreds and hundreds of homes on either case.
Yes.
So 600 or a 900 home shortfall, that's a very significant number of households in need of a home who aren't currently being provided for.
Yes, and that's viewed in the context of the significant improvement in housing land supply. I mean, it's a lot better than it was when we were looking at 2.7.
Well, we'll get to that in a moment, but given that there's still a significant shortfall, as we've just agreed, a step change in delivery is going to be required to get the council back onto even footing.
Well, there has been a change in delivery. There have been sites coming forward that have, since those previous appeals were determined 2.7 years, are now significantly improved.
So a further
that
step change is required.
No, I would say the trend needs to continue rather than further.
And you heard what Mr. Pycroft said. It doesn't look like it is continuing. No one contested that on behalf of the council.
I would say no, in that there are a number of applications in the system. Yes, there are also appeals. Position is going to change.
And what you say is that the positions improved from the 2.7 years in December, but I mean, it's still considerably under what are meant to be minima.
It's under the 5 years, yes, it is.
It's considerably under. I think that's fair. It's not. We're not at 4.8 years. You know, it's considerably under a minimum
Yes,
requirement.
we're not at 4.8 years, but there are a number of authorities below 2 years. There are a number of authorities, including this one, previously below 3 years. It's not worse than a number of districts. It's significantly better across the southeast.
Well, okay, so we agree those caveats. It's considerably below the 5 years.
Yes.
And of course, that improvement from 2.7 is that an improvement that you say tips the balance?
In terms of significant, I still afford significant weight to the shortfall versus 5 years. And it was in the other appeal decisions that referred to, they also report significant weight.
So if it was
2.7.
if it was
So-
2.7, you would still say significant weight.
Sorry, good.
So there was one appeal decision where it was determined to be substantial years. The other appeal decision referred to 2.7 years as significant. Generously, I'm saying it's significant as well. Albeit I think there was a material improvement in getting to 4 years.
You're considerably below the 5-year housing land supply. There's hundreds of homes with a shortfall, and you're now suggesting it's generous to say it's significant weight to the improvements. I mean, that's just not reasonable, Mr. Moss.
But I am still saying it's significant. It's significant when it was 2.7 years, and significant now it's nearly 4.
So you wouldn't say it was more if it was 2.7.
My view is it's still significant.
So there's been no material change then since officers considered it at committee.
Well, yes, it is within the boundaries of significant in my view, but within that, there was obviously a significantly improved position, and I think that is relevant.
And notwithstanding the improvement, we agree that the overall acute and pressing need for homes in the district continues. And the reason for the improvement, as we've heard, it's not because of some radical change in approach by the council. There's no new local plan, there's no new strategy, no new sites allocated. None of that.
No, it's the national change that takes time to work to respond to.
And as Mr. Pycroft explained earlier, in the context of a need that could be as great as 900, only 63 of the increased units are from new dwellings consented by the council.
Yes, albeit there was a recent approval of the evidence, there was a recent recommendation of approval from 55, as I said, there's 1700 in the system. There are other applications out there.
There are, but we don't have any. Yes, and they may well be refused because a huge amount of the supply has been on appeal, which appeals that Malden has lost.
I believe there are other appeals that potentially in the future.
So the only reason matters are not even worse here is because the council's propping up its housing land supply with windfall schemes on greenfield sites, many of which were granted at appeal.
Yes, I think that's fair to that, because we don't have sufficient allocated sites. That's why we're here.
And if we put all of this in the context of the MPPF, we talked about paragraph 61, the objective of significantly boosting supply. That's an objective that's being failed in Malden.
There has been significantly increased supply. So you've explained how that's occurred, but there has been.
Well, Malden is failing to achieve what national policy requires, which is a 5-year housing land supply.
Yes, but
Yeah.
improving the
And it's failing to achieve a core objective at the heart of the MPPF.
yes.
And in terms of the weight to the housing, so the approval of this scheme would provide for approximately half a year's housing land supply for the district as a whole. Yeah.
5 years.
But just to give a sort of sense of scale.
A sense of scale, yes.
I mean, you said earlier that if it was even 2.7 years, you'd still be saying significant rather than substantial. How bad would it have to be for you to put it up to substantial?
Substantial. It was determined by various appeal decisions. 2.7 years was significant.
Get to the appeals in a moment.
When you're looking at the order of when it becomes substantial, and that's fact and degree, certainly below 2, that certainly is substantial. The inspectors have determined, as I say, significant.
Well,
within that context,
And in terms of those appeal decisions, I mean, I think you've been slightly partial and unfair in the approach you took in chief, because you took the inspector to two decisions where there was significant weight. You didn't take the inspector to any of the decisions where there's substantial weight. Of course, we know that there are those decisions. There's CD Q24, so 200 homes. And at paragraph 78 of that, the inspector gave substantial weight. You're aware of that one?
Yes, I am aware of that.
There's also the Latchington appeal from 2024, which is CD Q21. So that's at the time the council had a 5-year housing land supply.
But that's also at the time there were significant concerns about the strategic development, strategic sites being delivered.
Right, so Latchington, and that's CDQ21, 5-year housing land supply. The inspector emphasised there that paragraph 31, 5-year housing land supply, not a minimum. Paragraph 32, the scheme would deliver 160 dwellings, so less delivery than here.
Yes, but this is all prior to the new test. I'm referring to decisions subsequent.
What we're talking about is the extent of the shortfall and whether your weighting is reasonable. You've said you've relied on 2 appeal decisions. I'm just pointing out there are other appeal decisions that say entirely different things. Because Latchington, there is a 5-year housing land supply, but given the importance of housing and the MPPF and the benefit of the delivery of 80 units of housing, the inspector there gave substantial weight, notwithstanding there was a 5-year housing land supply.
But the substantial weight was the combined benefit of both the 5-year housing land supply and the affordable housing.
Yeah.
It wasn't in isolation.
Yeah, so it's 160 dwellings. Provision of both market and affordable housing together attract substantial weight. So different inspectors are dealing with this differently. Some substantial weight, some significant weight. We don't know what their scales are.
Yes, what I would say is, in this appeal, as is consistent with the more recent appeals, we've applied affordable housing and 5-year housing land supply appropriate weight separately. This one has combined the two to afford substantial.
So your view is essentially it has to get so bad that it's below 2 years to get substantial weight. But of course, the only way you're going to get the windfall sites you need to get the supply back on track is, of course, to allow applications and appeals on sustainable sites.
Yes, in the context of the land supply position in the place of now.
And the only way you can do that is if you attribute enough weight to housing.
Yeah.
And if you only give substantial weight when things are bad, so much worse, you're never going to get back into the position you need to be. It's a self-defeating cycle.
No, not necessarily. Each can go through merits, and at this point in time, the housing land supply position, each appeal will be assessed against the significant weight to be applied to housing land supply. Be determined accordingly, and then if there does then be become a shortfall, then the decision will be up to yourself. We are where we are now.
We're going to move on to talk about affordable housing next. So what's proposed here is a 40% or 110 homes as affordable.
Yes.
A 10-year split of 75% for affordable rent and 25% for intermediate. And this is all set out in the affordable statement of common ground, which we've got at CDS4. And that 10-year split is supported by the council because it reflects the most acute local needs. And we agree access to affordable housing is a significant issue in Malden.
It is, yes.
The need for affordable homes is acute.
Which,
And more affordable housing, it's fair to say, is urgently required.
yes, affordable housing is needed.
And it's one of the key priorities of the council in the plan to boost affordable supply. And we've also agreed that when considering the weight to affordable housing, it's appropriate to consider affordability indicators.
I would say the affordability indicators reflect the overall need for affordable housing. In terms of the affordability, if that is a product with not having a smaller private units, partly, as a consequence of not having the right mix of units, you then have the affordable housing to access the housing.
Sorry, it just back to the question. It's appropriate in considering the weight to affordable housing to consider the affordability indicators. I mean, we've agreed that in the statement.
Yes, in identifying that there is a need for affordable housing. Yes.
Because what they do is they illustrate the pressure that exists in the housing market and on the affordable stock.
Shows the slide.
And we've got the statement of common ground, as I said, S4. We've also got the addendum statement of common ground that was submitted just before the start of the inquiry. Do you recall that?
Yes.
I'm not sure what reference that is. S6. So and that confirms 2.3 to 2.4 that in 2025 the lower quartile house price in Malden district was 11 times lower quartile earnings and persistently above the east of England and England over the entire LDP period since 2014.
Yes.
And then in terms of the main statement of common ground, we know there are some 700 households on the council's housing register. And we know the waiting time is, on average, is not months but years.
That would be, I believe.
So it's CDS4 at 5.5. Across the district, the average waiting time for an affordable home is more than 2 years, 27 months. .5. And then we've got in Mr. Wheeler's appendix, but I don't think the council has contested this, some more data on bids, and it's been submitted by Mr. Roberts that each 3-bedroom property that becomes available is subject to 169 bids. You recall reading that? Yeah. I mean, that's a staggering figure, isn't it?
Common across the South East.
And we also know that in the last year of monitoring, the council accommodated 138 households in temporary accommodation at 5.7 of S4. I mean, you've seen this. You've seen this and
I have, yep.
taken it into account. Yeah. I mean, by any measure of affordability, it's fair to say this is an authority that's in the midst of an affordable housing crisis. And urgent action has to be taken to deliver more affordable homes. I want to look then about the delivery and the need. So I think you said you've seen S4, going to look at some of the points in section 3 of this now. So the first point is about the need. So back in 2014, and this is at 3.1, the 2014 SHMAR identified a need for 182 affordable dwellings. Then we had in 2021 a local housing needs assessment went up to 209 dwellings. And in 2025 it went up again to 284 dwellings.
Yes.
So need is rising all the time. And that's set against, and you see this in figure 4.2, so we're now at a need of 284, delivery of just 89 dwellings per annum across the district since 2014. Figure 4.2.
Yes.
Yeah, so you see net affordable housing additions, average PA at the bottom there. So There's been 89 average net additions across the district since 2014.
Yes, it's 2014.
And I've just done some very basic maths, but even against the 2014 SMAR need of 182, that's a shortfall of 1,117. So it's 12 times 182 is 2184. And then you take away the delivery of 1067 and you get a shortfall of 1117 against the 2014 need. So the affordable housing need we've agreed is acute. It's also persistent and chronic.
Yes, but I would also add that very low supply in the period.
And we also know that, of course, beyond 2020, the local housing need figure's gone up and it's now at 284 DPA. And you can see there we're nowhere near 284 in any of those recent years. And going forwards, the council's identified supply of affordable homes for the next 5 years is also going to result in an accumulated shortfall of many more hundred homes, isn't it? And that's all set out in Mr. Roberts' evidence. So, Mr. Roberts' evidence, so do you still have his report open? So CDE3, KW4, which is Mr. Roberts' report, and it's page 69.
Page.
So 14B or 13B, so looking at shortfalls over the next 5-year period of somewhere between 890 and 965 dwellings.
Yes.
So there is a substantial and there's also a growing shortfall of affordable housing. And on this one, would you accept that a step change in delivery is required?
In terms of affordable housing, sites need to come forward providing affordable housing, and we've seen on other sites that they've gone above policy requirement to mark that. Step change does need to be as part of delivering more housing, delivering more affordable. With that, more housing delivered, more address the affordable.
And of course, we went to at the start 8B of the MPPF, which is all about ensuring a sufficient number and range of homes can be provided to meet the needs of present and future generations. So that's an important government objective, isn't it? And meeting the needs of present and future generations, it's a fundamental tenet of what planning policy is all supposed to be about.
Yes.
And that's being failed in Malden in respect to affordable housing.
It needs to be, there's still a need to address.
And that affects security, stability, health, mobility, development of some of the most vulnerable people in the area. Because what it means, as we know, families unable to afford somewhere to live, more people on the housing register, people having to find places to live further from their networks, where they work, all of those terrible consequences of the affordable housing crisis. And in terms of the scale of our contribution to meeting those needs, in a single permission, this would provide more affordable homes than the average per annum across the district as a whole over the last 10 years. We saw that figure of 89 DPA.
Yes, but not recent years delivery. Yes.
I mean, given the scale of the shortfall, and the scale of the contribution and the importance the planning system puts on meeting those needs. I mean, whatever adjective we use, this has to be top drawer weighting, doesn't it?
No, it's a policy compliance provision, and I've said in their examination in chief, the approach has been consistent. The scheme isn't acceptable without policy compliance provision. Other schemes have got to substantial top level weights by delivering more than policy compliance.
So the reason you've downgraded it is because it's not delivering more than policy. But we've agreed, haven't we, that policy H2, which is the requirement, it's agreed in the statement of common ground that that is there to secure a benefit rather than to ward off a harm. So CDS4, the statement of common ground we were just in, paragraph 2.3.
So it's the delivery of affordable housing independent policy.
So it would be wrong to reduce the weight on the basis of policy compliance because the policy is there to secure a benefit.
No, I think it is a benefit. I've accepted it's a benefit. It's a significant benefit in accordance with policy.
Okay, well,
If you wanted to provide more housing, then surely it would be afforded greater weight.
so I think it's ultimately a matter we'll make submissions on, but I'm just going to give you a chance to have a look at the case law that's really clear about this. So it's the Vistry Homes case, which is core document Q28, Vistry Homes judgment of Mr. Justice Holgate from 2024. You could go in there to paragraph 157, please, which is on, well, we'll start a bit earlier. So this whole section is about a case where an inspector reduced the weight to BNG on the basis that it was compliant with the incoming statutory requirements. So 152, the High Court judge says where a development's required to provide a measure to overcome or mitigate or compensate for a harm, ordinarily that's not a benefit. But then 153, BNG is an improvement, and that goes beyond offsetting the adverse impacts, and that's a benefit. And then 154, I don't see why the identification of a benefit has anything to do with whether it's imposed by planning policy or by legislation. Whether it's a benefit depends on its nature and purpose, including whether it would help to meet a need. For example, we often find substantial weight to the provision of housing, where there's a shortfall, sometimes very substantial weight, although that level of provision is a policy requirement. And then if she continues, paragraph 157, I turn to questions of weight. If a decision maker were to reduce the weight, which he would otherwise give to a 40% provision of affordable housing, because the development will provide the level of housing required by the plan, that would be objectionable, certainly in the absence of any logical explanation. The decision maker should be assessing how the developer's contribution stands in relation to the justification in the plan, and key considerations could include the level and nature of the need and any shortfall in delivery. And he says at 158 the same in respect of BNG. So essentially you shouldn't reduce it because it's a policy or statutory requirement.
Accepting it as a benefit received.
Yeah. So 157, it would be essentially irrational to reduce the weight on the basis it's policy requirement. Do you accept the decision of the High Court on
I
that?
accept the decision of the High Court saying policy compliance doesn't mean it shouldn't be afforded weight. It's been overcome in that they're saying it should be afforded weight as a benefit even if it's policy compliant. Accept that.
They're saying it shouldn't be, the weight shouldn't be reduced on the basis it's policy requirement.
Yeah.
So you said you've reduced the weight on the basis it's policy requirement. Do you accept that's wrong?
So when I'm looking at this particular case, I don't know what the provision was.
It's an example at 157. it's not related to that case, that the court's saying, and this is a general approach that's accepted in many appeal decisions, that it's wrong to reduce the weight for a benefit where the policy is to secure a benefit on the basis it's policy compliant. Do you accept the inspector would be wrong to reduce the weight for the reason you've reduced it, looking at that High
No,
Court
no,
case?
I'm saying that when you're looking at the weight, it's reasonable to apply significant weight to this benefit. It would be unreasonable to reduce it to moderate weight because it's policy compliant. It's reasonable if it were to deliver above policy requirement to afford additional weight. That's my position.
Okay, well, I think ultimately have to be for submissions because
There are appeals consistent subsequent to this judgment as well, which in this district.
okay. The only point is that you've given one reason only for reducing the weight, and that's because you said it was policy required. And I'll make submissions about
I'm
that.
conscious we've been
Yeah,
going for
just
about
go
an hour
through
and a half. First of all, how are you there, Mr. Morris? Okay. Any ideas for timings?
I mean,
going
we're-
forward?
Maybe 3/4 of the way through, something like that.
Okay, I think that we probably keep going because I'm still minded if at all possible to fit Mrs.
Okay.
Bosley in. So, okay, fine, keep going.
Keep going then. So, going to move on to some of the other benefits of the scheme then. So, first then, so what's proposed in terms of the cemetery? So, 1.8 hectares of land for the cemetery adjacent to its western boundary is what's proposed, as we've discussed. And we've got the evidence from the council. We don't need to go there because I don't think you can test it. CDJ12. That the current rates in 2023, the cemetery would reach capacity within the next 8 years.
That's good.
Yeah, and that's the council's stance. So we're now 3 years on, so 5 years of capacity.
How that's changed and whether that's the case.
Well, you haven't put any evidence
No, I
to
haven't
say
got
the
any
council.
evidence to the contrary, but
Yeah.
we will see referring that.
And in addition to this specific cemetery, it's agreed between us in the statement of common ground that there's a pressing need for cemetery capacity across the district as a whole.
Yes.
And on that basis, the officers in the report thought significant weight should be given to the provision of land.
You take me to that paragraph to remind me.
Yeah, it's CDC8 5.14.4.
CD,
C8 is the officer report.
okay.
PDF 45, page 57. It was actually at the top of page 58 of PDF 46.
Yeah, that's what they officers afforded
Yeah.
to it.
Do you accept, like Mr. Slack did, that the inspector would be right to give significant weight to the views of the council's officers in this report?
The application was determined by members. It is clearly significant weight should be afforded to the officers' advice for the employment.
Yeah. I mean, the only reason you've downgraded it, you explained in chief, was because you suggest it could come forward in isolation. You recall saying that?
Yes, it's not predicated on this site being developed for housing.
There's no evidence whatsoever that would happen. It hasn't happened to date, has it?
It hasn't happened to date, but if this site was left out of the reserve site previously, there's just as I said earlier, there's a land deal that can happen here, or expansion of the cemetery, whether the site is within the red line or it's not.
I mean, it's just pure speculation. There's no evidence that that's got any likelihood of happening outside this appeal scheme. That's fair.
I mean,
No
there's
evidence.
nothing to say it won't. There's no evidence to say it will. No evidence to say it won't. In the same way, does it make a material difference whether it's in the red line or not?
Well, I think what you're suggesting is the inspector should reduce the weight on the basis of some theoretical alternative with no evidence in support of that. And again, it might be one for submissions, but
No, I wouldn't. I would argue it's not theoretical. The land can be brought forward as a cemetery with a land deal inside or outside the red line.
well, I mean, the appeal site could be brought forward for a solar farm. I mean, the pure speculation what could or couldn't happen, and there's absolutely no evidence to say that would happen outside the confines of this scheme. It's pure speculation.
Yes, but equally, then you're saying that the land deal it may not happen with it.
So I mean,
address that with a legal agreement as a condition.
we've seen Mr. Sorry, the inspector's comments on the conditions, and we're looking at whether that can be addressed. I mean, what I will be putting in closing submissions is that it would be irrational for the inspector to reduce the weight on the basis of some theoretical alternative proposal in light of the case law on alternatives. Just so you're aware that that's
Yes,
the case we're going to be made.
I understand what you're trying to push me to saying, but what I'm saying is that still, if this site isn't built for housing, as I've said a few times, there is potential to do a deal on the land for the value of the land as a cemetery. I don't think that's an unreasonable position.
The question is whether that's a reasonable reason to reduce the weight. But I'm going to move on because I've made the point, and I think it's ultimately
there's a
illegal.
judgment. Obviously.
The nursery, we've agreed significant weight, so I'm not going to ask you a whole lot of questions about that.
Yes, but I would, as I mentioned, I think there is a degree of uncertainty. It was appointed by the council, it's a private nursery potentially. We would, as raised in the opposite report, I
Of
do
course.
mention also the other appeal where private nursery was proposed, or land for private nursery was proposed, that's in 21, and then it was only afforded some weight, which is
Yeah, and you said some weight was limited. There was no basis for reaching that conclusion. But in terms of what has been agreed, in terms of this nursery, it's agreed in the statement of common ground that it would offer diversity of choice, including provision for 0 to 2-year-olds and childcare outside of term time. All agreed?
yes, it's
And agreed that paragraph 100 of the MPPF acknowledges the importance of early years places and having choice in early years places, and requires council to take a proactive approach to widen choice in education. We've agreed that.
yes indeed, and then there's
And you referred to the officer's report, identifying some of the points you've made, but they, of course, gave great weight to the nursery provision in the officer's report. The same paragraph we were on. The paragraph after we did the...
yes, the NPPF specimen. That's the view again of officers.
So, next then, climate change mitigation. So what's proposed is a community smart grid which would have shared solar panels and battery storage, and it's expected this would meet 60% of the site's electricity demands. And when that's combined with the other efficiency measures proposed, the evidence submitted shows that results, as you said, in up to an 80% reduction against the Part L 2021 baseline. So that's a significant exceedance of the 2021 requirements.
Yes,
And it's also an exceedance against the new future home standard, isn't it? I don't know if you've calculated it, but it is, as a matter of
I haven't
fact.
done the calculations. Obviously, the future home standard set out.
Yeah.
That's looking to get towards zero carbon through improvements of up to 25%.
And it wasn't a point I had understood from your written evidence, but the inspector did ask you specifically, and you said it wasn't an improvement against future homes.
Like I said, it's within the range.
I'll get Mr. Wheeler to explain it tomorrow because he will give a sort of, it's a factual point. But if it is an exceedance of future homes, which is what I understand from Mr. Wheeler, would it be fair to give it more weight than you've done?
It's a private benefit that's mitigating the harm caused by the site. It is going to seek to offset that.
Even if it's significantly in excess of the current requirements, and in fact the innovative approach is in excess of the future home standard that's yet to come in, that doesn't, you know, it's an approach that's not required.
It's determined to be significantly in excess of future standards. Then my view is that it's because it's private benefit to offset that carbon impact on this.
It is, but if it's more than doing what's currently required, there's a public benefit to that in reducing carbon, isn't there?
Broadly,
Yeah.
broadly,
So if it's in excess not only of the current but the future requirements, do we accept that moderate is a fair weighting?
I'm still right according to the nature of it offsetting the harm. What is carbon relevant these days and the overall impact of building houses is really good.
It's also got a separate benefit, doesn't it, in reducing household energy bills. The evidence says by approximately 15%, and that would be helpful in addressing fuel poverty and cost of living pressures, particularly for the affordable housing.
Yes, and that would with having provisions to reduce reliance.
That's something the inspector can take into account when considering the weight. So there's another number of other benefits: BNG, economics, open site, footway improvements. There's agreement between the two of you on some of those, and slight disagreements on others, but I think for the most part the cases are set out respectively in writing, and the inspector's taken the proofs as read, so I don't propose to go through all of that in a great deal of detail. Mr. Wheeler can pick up any additional points tomorrow, if that's okay with you, sir. Then I'm just going to move on finally to a few points on the adverse impacts of the scheme, and finally just a final point on the balance. So in terms of the harms then, we've agreed, of course, that it's inevitable greenfield land needs to come forward to meet housing requirements in this district.
I accept that is
And so there's going to be, with any such scheme, some inevitable adverse effects on landscape and visual matters.
yes, to a certain degree.
And I'm not going to revisit any of the evidence of the landscape witnesses. Safe to say, we've agreed that this is not a site that's designated at any tier, nor is it a valued landscape.
This is not designated as value landscape. As I said, there are no local landscape designations.
And you'll recall the agreed position between Mr. Cowlin and Mr. Mitchell, whose second name briefly escaped me, was that the landscape is of medium sensitivity.
I think, yeah, go back to that.
About the
Yeah,
quality
medium
of the landscape, yes. And of course, as we've said, the council has previously said an even bigger site here could be suitable for residential development.
Yes, a wider site, the relative, as I said, the relative harms of 800 homes to the landscape impact versus 275. It's all relevant.
I mean, and there's nothing really out of the ordinary in terms of the impact here. It's just what Malden's going to have to inevitably accommodate to keep moving forward in the landscape.
yes, there will be harms for Malden on various sites, but we have to look at the specifics of this. And I've mentioned, as did Mr. Cowlin, reduced development away from the park site would reduce the harm.
And is it fair then to say, given all of that you've acknowledged about the inevitability and this isn't a valued landscape, it's medium sensitivity, if the only harm was landscape, you wouldn't be recommending refusal because you give it significant weight and you give the affordable and the market housing separate significant weight in favour?
You have to look, yes, I think you look at the overall planning balance. It of itself, was a refusal reason. You set it against those other provisions. Were you to determine that the level of transport, then you could just rely on it.
That's very fair, thank you. So, just briefly, I should have touched on this earlier before we move on to heritage. We did D1, H4. I'm sorry, I should have gone to this at the start, but the inspector asked about it specifically. So it's just a very brief question, but this is a policy that's about density and effective use of land.
Optimising the site, which is trying to get to the
Sorry,
quality.
CDJ1 is the plan. My fault for not dealing with it earlier. H4 is on page 88. I think the only part of this the council's alleging any conflict with is the first section, it's not the other sections. And that first section, it's got the heading density, and we're agreed that the density here is appropriate. I just don't understand.
The policy, okay, yes, the wording is density, but the provision there is all development to be designed to optimise the use of the land, having regard to these considerations.
It's all about density, isn't it? I mean, in the same way that the bits below that are about alterations and, they relate to the headings. This is about density, and we agree the density is appropriate.
In terms of dwellings per hectare, in terms of 275 units and resultant impact, in terms of optimising the use of the land.
Okay, I mean, I don't think we agree with you on that. We'll hear what Mr. Wheeler has to say. I just don't see that that's a relevant policy when there's no critique from the council of the density proposed. But the inspector can take a view.
Yes, albeit optimising the use of land in respect of capacity of the local infrastructure, character of the location, etc. So, yeah, I can agree to disagree.
Heritage, very briefly. So, agreed it's not a reason for refusal. We're agreed the impacts on Headlands Barn, which is the grade 2, is low level and outweighed by the public benefits.
Of itself, yes. In terms of heritage, heritage is not a refusal.
Yeah. And on the cemetery, the non-designated heritage asset, given this is not meant to be rude in any way, you're not a heritage expert. I understand you're relying on the conservation officer's response
Yes,
on
I am.
that. Yeah.
I am informed by the advice.
Yeah. And Mr. Wheeler's done the same. So what Mr. Wheeler's relying on, just for the inspector's note, is the heritage note at Appendix KW2, and that sets out our position. And I think he'll just have to take a view as to whether the harm is, as the council says, limited to the cemetery or none, as the appellant says. That's something the inspector will ultimately have to just take a view on.
Indeed, and obviously I've been to site and we've seen the tranquility of the setting, and as I mentioned in the examination issue, I think it's a blunt instrument to try and ask if there's any landscape.
And I just wanted to confirm, because I wasn't totally clear from your evidence, the inspector asked about other assets. Just to be entirely clear, it's agreed in the statement of common ground that there is no harm whatsoever to any other assets other than those two. That's still the position. Yeah.
We're not.
Highways then, of course, you rely in your proof on the fact that on the reason for refusal to reach your weighting. Is that right? The question I have is because Mr. Slack told us he hadn't told the council that 3 of the 4 elements of the reason for refusal couldn't be defended, and only 1 of the 2 junctions in the supplementary statement of common ground could be defended. Were you aware of that when you were giving weighting to the highways impacts in your proof?
I was mindful of there being overall impact on the roundabout. Was I aware of it potentially? Yes, I was, because Mr. Slack told me that he wasn't able to model the other junctions. He was therefore only relying on being able to assess the noise.
So your substantial weight is just about there being impact on one junction, not all arms of it, and at certain times of the day. On that basis, you give substantial weight
Yes,
to the
because
highways.
of the broader impacts associated with journeys across the district by a number of people daily as they go to work, travelling peak hours. That's a substantial impact that is not well beyond the top.
Well, of course, the test at the MPPF is that schemes shouldn't be refused unless the impact is severe.
With respect to transport,
Yeah.
refuse purely the transport.
Yeah. So that's, as the witnesses agreed, an intentionally high bar.
Transport, yes, but that's separate to the weight.
Yeah, but as the plan, as Mr. Bancroft explained, the Highways Authority has its own responsibilities to manage the road network to ensure the free flow of traffic. So that bar is intentionally set high, so planning doesn't get in the way of what's another authority's statutory remit.
In terms of the
116.
the 116 test, yes, and in terms of severe impact, that's relevant, obviously, for that refusal reason. So obviously, I've said separately the plan of consideration, irrespective of whether it kicks into severe harm or not. That's a substantial way to be forward.
That's totally inconsistent with what the MPPF says, because the MPPF is saying don't refuse unless there's a severe impact. So an impact that's not severe is not a harm the MPPF is trying to avoid.
That's purely in respect of transport. If
Yeah.
there was a significant adverse impact to heritage, you refuse purely on adverse impacts to heritage. But there's still the harm that needs to be weighed in the back.
So there's a threshold in the MPPF, don't refuse unless the impacts are severe. This scheme complies with that threshold on Mr. Bancroft's evidence. Yeah, and if that's right, it would be totally contrary to what the MPPF is trying to achieve, to give substantial weight to the impact in any event. Would you be giving substantial weight? There's no other threshold. Would you be giving substantial weight in every single case where there are transport impacts, because there are transport impacts from development?
No, because the transport impacts are materially felt by the wider population in terms of delays resulting to, as I mentioned in the examination of the chief, that you lose a working day year potentially to
Yeah.
traffic, and that is a substantial impact on everyone's daily life.
If any scheme that gives rise to transport impacts, unless you've got a threshold, and the threshold here is significant, is severe. If we're not over severe, it's totally contrary to the MPPF to still give substantial weight, because you'd be giving it. There's no other measurement by which the inspector could give that weight compared to any other case that gives rise to transport impacts. The point of the MPPF is to say, if you're not severe, that's acceptable in policy terms.
I'm still disagreeing with this. I think if it stands alone for a severe impact, that justifies refusal.
Yeah.
If it's less than severe impact, it still needs to be weighed in the planning balance. I mean, I consider, from my professional perspective, that impact is still substantial, whether it ticks into severe or not.
Notwithstanding if it's in total compliance with national policy.
if it complies with that element of the MPPF,
Yeah.
it doesn't, there's not sufficient reason for refusal purely on transport. It's still considered a substantial weight of the heart, even identified.
And when you're giving substantial weight, it's got to be a proportionate adjective that's consistent with the extent of the scheme's impact, isn't it? And of course, I mean, you heard the evidence, I'm not going to go over it, but the marginal impact from this development, we heard the RFC is 0.02 at worst. Do you remember that?
Yes, but we don't live in 0.02. We live in a world where our daily impact is how we experience it,
Yeah.
how it affects our daily life.
And we heard the delays are at worst 30 to 50 seconds at one junction and only in the AM and PM peaks. Yeah. And that was what Mr. Slack said we should focus on. So those are very marginal changes at one junction at one point in the day. I mean, giving substantial weight to that is just not a reasonable assessment.
It's a very busy junction, it's widely used, there's few alternatives. It is going to be felt, I think that's reasonable. It's going to be resulting in queuing, it's already, all of these reasons are why it's substantial.
Just to calibrate a bit, that's more weight to that impact at one time of day on one junction than you've given to the entire affordable housing or the entire market housing delivery of this scheme. That doesn't sound quite right, does it?
It's a harm of development.
There's one other impact then I just want to touch on, which is tree removal. And I mean, none of the trees that are removed are category A trees, that's right. And none of them have policy protection.
Yes, albeit the authority doesn't serve every tree.
And 350 new trees would be planted. And it's been agreed in the statement of common ground, I don't know if you signed this or your client signed it, that the arboricultural impact will have a short-term impact and will be mitigated by the establishment of new tree planting.
Yes, the short-term impact is over a considerable period of time.
So it's agreed it's short-term and will be mitigated. Well, it says will be mitigated in the statement of common ground. And I mean, Mr. Grant anticipated the question because it's an obvious one. I mean, that the reasons you gave for that were related to the screening, the amenity impacts. I mean, that's just simply double counting the landscape weight.
There is a
So if there's a degree of double counting, is it fair to reduce it from moderate to limited? Well, on your, are you happy to reduce the weight given that what you said for landscape? Notwithstanding accepting that you've double counted.
Mindful of counting, discussed.
Okay, so final question then. Final question then. So just to go back to the original paragraph 11D. So the test here is not simply whether the benefits are outweighed, but whether they're significantly and demonstrably outweighed. The MPPF.
Yes.
So in a world where the highways and landscape impacts are evenly balanced with the benefits, what the inspector has to do is allow the appeal.
Yes, they have to outweigh.
If they're evenly poised, the appeal should succeed. Okay. Thanks very much. I think those were the questions.
Thank you, Sharon. Thank you, Mr. Moss. Just I don't think I have any questions. Mr. Grant, anything in re-examination?
Um, yes, sir. A few points. Just a quick query for you as to how there's obviously a point between us about picking up non-severe traffic harms and waiting. You'll mention, sir, when this was meant. You'll remember, sir, when it was listed for 3 weeks, I said I had a court case next Tuesday. It is on that exact point. So I don't know whether you wanted to, we can fully ventilate it here and I'm happy to do so, or we can leave it over for the discussion of whatever the judge says and let you know in writing. I'm ambivalent. I just, given that it seems to be on a point that I thought I should raise it with you as to how you'd like us to deal with it.
What I'd like to do, if you're going to give me any evidence, give it to me at this inquiry.
Yep.
Because my habit is one other than maybe a Section 106 agreement. Once I close, I'm not going to accept any further submissions. So, if that's a point that you want to pick up now.
That's absolutely fine, sir. Check. Thank you. I'm grateful. A few questions, Mr. Moss, in re-examination. We'll go back. First one, so pick up traffic, starting with traffic, please. One of the points that was repeatedly made was that the impact to the extent that arising are only happening at certain points of day. I infer that's the AM and PM peak.
Yes,
How common is it to look at traffic impacts in the AM and PM peak?
that's the main purpose of assessment, because that's when the conditions.
There was a point suggested to you that the reason the severity threshold is so high is because the Highways Authority is the one that has the responsibility for maintaining the network. What powers does the Highway Authority have outside of the planning sphere to stop development coming forward?
In terms of, well, it's a decision authority, they're not really their advice is, as a statute comes to informs the planning officers in reports.
There were a number of points were put to you on, for example, the nursery and the cemetery about reduction. The general format was the officer said this, you said this, why are you reducing weight? Now, let's be clear. When you were recording your weight, were you going through that exercise? Officer says this, I am going to reduce and why? Or were you starting with, or were you doing something else?
I read the
Is it fair to characterise you as reducing weight? For any reason?
no.
You were taken to Vistry. Can we go back to that, please? And there was some discussion about reductions based on policy compliance and
Tell
whatnot.
me that.
CDQ 28. And went through various paragraphs culminating in 157. Can you scroll down to paragraph 161, please? Page PDF and paginated, page 34. 161. So you were taken through various paragraphs on not reducing weight based on policy
Yes.
compliance, and then the judge says this. And again, this is the context in the context of BNG. I do accept Mr. Williams, who is Counsel for the Secretary of State, submission that the statutory requirement for BNG of 10% can properly be used as a simple benchmark for comparing the BNG to be provided for proposed development. That's been recognised in another case. But and then the limitations of using percentages as a comparator should be appreciated, and of course don't make any of the potential errors identified above, which is the ones you went through with the challenge. How relevant, if at all, is that to what you're trying to get at, trying to explain just how you feel about this?
Say a little more for me.
No, that's all right.
Can't be leaving you.
Yeah,
Okay. Sorry, can you repeat the question?
I was just going to ask how relevant is the points being made about benchmarking here
In
to the
terms
exercise
of-
to what you were doing, to when you were talking about 40% gets X% weight.
It's the same with the benchmark.
that,
No,
so
sorry.
that's fine. No,
Question.
don't think so. Not without leaving. A number of points were made to you about the weight, and if you only accord not 3 years, but significant weight, if you're below 2.7 years, you're never going to solve some crisis. Remember that exchange. In effect, I suppose the question was because one of your answers to the question of you can only do that if you attribute enough weight to housing, and the response I've got noted down is in context. So, I mean, how relevant are other countervailing factors to this question on specifically?
Supply positions, the supply position. Again,
What about it? Really it in terms of points that I needed to. Yes, so that's it.
Thank you, Mr. Brown. Okay. Mr. Moss, you can stand down. We are 25 past 3. If we take a short break, I still think we should have ample time to hear what you have to say, Stodsley, and obviously I'll be giving Ms. Shalaby the opportunity to ask you questions on it. You're happy with that?
That's fine. I just wondered if it might, I don't know if Miss Shalaby can answer this question, if she had an idea of how long she might be asking me questions
Not a
for.
bad question. Can you? In that case,
Thank you, I'm grateful,
I
that's
think
great.
it would be a good idea to do that. Let's
Agreed.
take a short break, however. We'll just take 20 minutes. We'll resume at 3:45. Okay, good afternoon. 4:45 and the inquiry is resumed. So we now come to evidence on behalf of the Rule 6 party from Ms Dodsley. Appreciate somewhat different set of circumstances, obviously, because you don't have a barrister to feed you questions. So what I did suggest yesterday was you might like to put a few bullet points together and just give us a summary, perhaps, of your main case. I'll take your evidence as read that you submitted earlier. As you know from the way that we've been operating, I'll give the appellants the opportunity to ask questions if they wish to do so. I may also have some questions as well. Other than that, in your own time, Mr. Dodsley, please kick off.
Thank you, sir. We'll keep it as brief as possible, as
You
you've said.
don't need to. This is your time to give your say.
Thank you. But taking my proof as read,
Yeah.
the first thing I want to really iterate is about the tilted balance and drawing attention to, and I mentioned this in my opening, that we don't say that Malden is a district that has failed to build homes, and coming back to the statistic of 142% on the housing delivery test before the algorithm changed. I appreciate my housing land supply figures may not be exactly agreed, but I'm just going to work from the statement that the council had published, which did say 4.1 years. So we say that, you know, the urgency of housing delivery, as we're now, we believe that the housing land supply is at 4.1 years is not as urgent as it might have been at 2.7 years, and that the council was worked incredibly hard to ensure it's compliant given that overnight change. The council is not, as it's been suggested, sticking its head in the sand, and in fact we would say quite the opposite, hence the improvement in that position from 2.7 to, let's say, somewhere around 4. And so I think I wanted to mention about it being open to you to be able to consider the reasons for the shortfall in housing land supply, and that it is open to you to take into account that there is a story here as to why we are in that position and the change of number overnight. And also that how the adverse impacts can override that tilted balance being available to you as well. The second point I want to make is about the spatial strategy. I know that's been touched on earlier, and I mentioned it in my opening. And we say that this is, you know, very real, very live, and really goes beyond any policies that might be deemed to be out of date. The site lies outside the defined settlement boundary, and that boundary is not an arbitrary line. It is a real physical expression of that strategy that was tested and modelled for. And I want to mention that in Policy S1, it talks about how important it is to provide land of the right type in the right place at the right time. And that's something that we say isn't fulfilled here, and all members at the planning committee agreed. You know, and those members represent areas across the whole district, not just Malden as in the town. So they are acutely aware of the community and the communities that they serve in, the, you know, in their smaller villages, and acutely aware of the pressures that we are under infrastructure-wise. The policy talks about the importance of the rural character of the district, and we say that this proposal will allow the open countryside to be built on, and we feel that should be protected. There's mention in the officer's report about the site being currently unsustainable. I know there's been a discussion around that, but I'm drawing attention to that. We support the landscape view of Mr. Cowlin, and also just mentioning briefly infrastructure struggles. NHS have made comments around capacity or lack of capacity for growth. There's something else in S1 which talks about meeting local needs, really against this overarching principle of Malden District Council, where they talk about where quality of life matters. And that feels important to us as a group, because we question whether this development would actually meet the local needs. there is obviously a very generous affordable housing offer within this proposal. And one of the concerns around that is that reduces the opportunity to build, or we say it reduces the opportunity to build lower quartile housing. So we never address our affordability problem, and then properties in the district continue to remain unaffordable for the young people that live here. And so the target that we have, this 584 or 586, is a target, we say, that isn't necessarily based on need. It's to do with the affordability ratio. If our affordability ratio was lower, then our target would be lower. And we get stuck in this kind of cycle of continuing to build to try and buy ourselves out of affordability crisis that we can't solve unless we build more lower quartile housing. And essentially it is a national target. A language was used earlier about it being a need. We would perhaps submit that it's a national target and linked to affordability. And the last thing I'm going to mention is about the comparison with the appeal at Southminster, which is Q24 in the core documents. That appeal was in March 2025 and at 2.7 years supply. And there was a large package of benefits, and the inspector dismissed the appeal because she believed the adverse impacts significantly and demonstrably outweighed the benefits.
Just remind me, what was that site again?
It's Q24, Southminster. It's in Southminster, within the district. And we say we are now at a higher level of land supply, so I've written here 4.1, but perhaps somewhere around 4. And so I would submit that it's open to you to take a similar view in this particular proposal. And those were the bullet points I wanted to raise with you, sir.
Thank you.
Thank you.
Thank you very much. Mrs. Chandler, anything at all from you? Okay. I feel I do have some questions for you, Mrs. Dodsley. I appreciate the amount of time, first of all, you've given here. And also, I have to say, I'm impressed by kind of understanding of an awful lot of the planning jargon, which I know we tend to, as professionals, trot out, but I know it can be somewhat daunting when it's when it's certainly to your first inquiry. But let me ask you some stuff here. You were saying that that recently the council has applied the housing delivery test, just which evidences the amount of housing that's being built in the district at the moment, and it's not so much a fact that the council has prevented development going ahead. It's more a case of the government, as it were, moving the goalposts in what the local housing target should be. But I was hearing evidence today and in previous days whereby, quite well, probably the majority of housing that's being built that has boosted that housing delivery test has come to a large extent through appeals, rather than the council either updating its local plan or recognising that it needs to produce additional housing and granting planning permission for it. What's your take on that? Is there some truth in that, or is that largely right? What's your feeling?
My feeling on it is there's been quite a journey in this district. I know it was mentioned earlier about kind of the changes in housing land supply over the years. I'm fairly new to my understanding of it, so I know that when the plan came in, we had a land supply. I know it dropped. My understanding is there were some administrative errors that had led to that. So my assumption might be that may have led to appeals happening. We then were at a 6.35 year position not too long before the algorithm change. So I think it makes sense to me that we've seen appeals, I think, because there has been this changing position. I'm obviously aware there have been strategic allocations with the garden suburbs and Haybridge that contribute to that. So I think I would describe it as an up and down journey.
Okay. Mrs. Mrs. Chowdhury in particular asked a number of pointed questions. It's not in particular. It's a housing supply for that as well. That the Bolton simply hasn't done enough to try and meet that. Do you recognise that there's a housing crisis? Is that what Malvern feels there to be?
I think the residents would say, and we would say, there is a need for a certain type of housing. We recognise the need for housing that is affordable. I don't think we would say there is a crisis here. That feels too far of a stretch. I think there is. I know from talking to families who have children, grown-up children who are, maybe looking to buy, looking to move out. That is a problem. So I think there is an issue with housing that is affordable. I'm reluctant to use affordable housing because I think there's different things going on here. But
so you're not just affordable housing in the sense that we inherit. So
yes.
Housing that's provided for people who can't buy on the open market. But are you saying that the type of housing that you feel that this would need, so as it were, market housing, but perhaps smaller, modest-sized units that are therefore cheaper to buy? Is that what I'm
yes,
hearing
and
you say?
I think if we're going to address the affordability problem that we have in this district, that is definitely one way to do it.
Okay, because I mean the council does have a policy which seeks to require a certain mix of housing. My understanding is that this scheme has been designed to meet this. So in the sense that it is meeting what the housing assessment says is the need, that would seem to address that concern of yours as far as this scheme is concerned. Maybe not looking at the rest of the
Yeah, I mean,
is that correct? You think?
I think in terms of in numbers, in number form, I can, if I take out our views about the site and the location, then yes, in number form, yes, I think it goes some way.
And then the last point you were making, let me just make sure I got this right. We're talking here about the government's standard method for calculating the housing. Did I hear you rightly that you recognise that you need some form of mechanism to identify need, but that's really done at a national scale, and perhaps the local requirements of Malvern might be somewhat different in the national scale. If not, correct me and tell me what you do mean.
I understand there has to be a national approach. There will be national targets. I think what I'm saying is that because our affordability is so high, that means that we have to build. Our target is much higher, which then puts additional pressure on a rural. We're a rural district. That puts a huge amount of pressure on us as a district to meet those numbers with the amount of land that is available.
Because the affordability ratio was built into the kind of documentary in order to try and address those areas where people are in affordable housing on the open market. Obviously, Malvern is one of those areas. If you don't have that, how is it where would one square that circle with people needing housing but being unable to afford it?
I think my understanding from conversations that I've had is that we continue. So the affordable housing comes forward as part of a scheme, but what we're not seeing enough of is, as I mentioned, like the lower quartile, so the smaller houses. So then our affordability doesn't ever get addressed. So we're constantly chasing something that we're never going to build our way out of that problem.
Okay, that's good. Thank you very much. Is there anything else that you would like to say on behalf of the All Six Party that We haven't, I haven't given you the opportunity to say.
I don't think so, thank you.
Okay, well, thank you
you.
very much for speaking. Thank you. Okay, thank you everybody for today's proceedings. Just looking ahead, tomorrow, now that we've heard evidence from the Rule 6 party, we have Mr. Wheeler's evidence and cross-examination tomorrow, and then because Ms. Dodsley's not here on Thursday, we're going to hear her closing as well. At the moment, those are the only two things. I'm starting to think that I have seen no reason why I shouldn't also be able to do the round table on the legal undertaking and planning conditions if both sides are able to do that, say tomorrow afternoon, barring the issue that I raised this morning with reps.
I think it poses difficulty for our solicitor who's not able to attend tomorrow.
Sorry, Mr. Wheeler's not
No,
here.
our solicitor, the
okay.
solicitor who was going to come and talk you through the Section 106 and
That,
the
that I
wording.
think is going to be quite necessary. Okay, well, in which
Sorry.
case, it was just an idea.
Sorry.
That's not a problem. It would have meant that you two would have had slightly longer.
But at least we have
tomorrow.
tomorrow afternoon now.
You do, I suppose. Okay.
Sorry.
In that, no, that's fine. That's part of the reason for me asking the question. We'll keep the programme as it is then. All right. Good. I have one issue which we'll pick up maybe tomorrow morning, which is the question of clarification that I asked for from Councillor Pittock on the question. Now, hang on. Well,
So having spoken to Councillor Pittock, I think it might best be dealt with by a note on the basis that I think what lies at the heart of it is there seems to have been some discrepancy on what's phase 2 and what's phase 3, both in some of the officer documents that have been created and transposing numbers perhaps wrongly. So it might well be that Councillor Pittock and Mr. Pycroft have been talking across purposes for slightly longer than it was realised. So the reason I suggest a note is because hopefully it can set that out more clearly than I can do
that's
orally. I appreciate Mr. Pycroft needs a chance to make comments and respond and
Yes.
whatnot. I'm not suggesting that be the final word, but I'm suggesting a note because it'll be easier than having it explained to you orally.
That sounds like a plan to me. So yeah, let's go with that. Okay. And then for my part, I'm chasing my case officer as far as those reps are concerned. But however, since we're doing the legal undertaking on Thursday, I think we should have adequate time. Good. Any other housekeeping matters, Mr. Wheeler?
Just in return, in terms of the NHS, we'll obviously have a look at the increase in contribution, but you're able to give us an indication of what...
I'm sorry, I've been able to read it, but I'm afraid for some reason my case officer hasn't been able to strip it out and send it to you. So hopefully he'll be able to do that either later this afternoon or tomorrow. I think it was down as 192, wasn't it? And I think they're suggesting something like 209 now. And it was based on their recalculation because of building increases in building costs. That was about the round of it. Okay. Right. I think then we are good to adjourn until 9:30 tomorrow morning. I'll adjourn until then. Thank you.